Edition allowed. Yes.
Lordship, I'm praying for listing of a motion matter on Monday, your Lordship. Dice code matter, Lordship, covered case, Lordship. Similar order may be passed, Lordship.
Next, Lordship, conduct petition, your Lordship.
Motion.
May please, your Lordship. Listing for
Take a date
motion
for me.
published.
My lord, admission matter after vacation.
May it please your lordship, I beg to mention for listing of a writ petition, lordship, matter pertains to appointment of graduate teacher. Next week, lordship, Tuesday.
There's a motion matter or admission matter.
Motion matter, lordship. Jobless.
May please, your Lordship. Lordship, I beg to mention the petition number 4240 for admission, my Lord. Lordship, the reason being urgency that last 1 month ago, my learned friend taken for 1 week to file the affidavit. Earlier, my Lordship, 3-4 times the government taken time to bring the instruction, my Lordship. So, Lordship, kindly put it before the vacation. It will just take 1 minute to my learned friend just say the when they'll file the affidavit, my Lordship. It's a matter, my Lordship.
No, admission matter before vacation not possible.
Lordship, humble
Immediately
prayer, my
after
Lordship.
reopening. January 1st week, take any date from him. Yes.
Yes, Lordship.
Yes. Mr. Learned counsel for the petitioner. You inform the other side. First inform the other side. Yes.
May please, your Lordship, the leading senior is unavailable today, so kindly requesting for adjournment for item number 8 and 9. Motion stage.
8 and 9.
Yes.
Miss, your good name?
Bini Raj Shah.
Learned counsel, learned counsel for the petitioner with consent from the other side. Press for listing the matter after
Wednesday.
Wednesday. Okay.
May I please,
Fair.
Right.
Yes.
my lord, I beg to mention item number 31, my lord. In this matter, I shall have to file an additional affidavit, my lord, for subsequent development. That's why,
31.
my lord.
Mr. T.U. Loskor, learned counsel for the petitioner, submits that he may be granted a 1 week time to file one additional affidavit.
My lord,
Fair allowed. This is a
Obliged.
matter. After vacation,
my lord, after vacation. Obliged. Item number 2.
May I please, your Lordship?
yes.
Lordship, petitioners are before the Honorable Court by agreed by the order SS 5/2025 passed by the DEO, passed by the DE Assam Lordship. Lordship, petitioners are working as assistant teachers in their respective school, Lordship, in the district of Nagaon under Botordroba block. Lordship, this order has been passed as a compliance order of the of the WPC number 1024/2023, Lordship, passed by this Honorable Court by order dated 2/5/2024, Lordship.
Mhm.
Lordship, by this order, the Director of Elementary Education has rejected the claim of the petitioners as Lordship, kindly peruse the page number 83. Type copy is, Lordship, page number 82. The order dated 5/2/2025, Lordship. Lordship, in this order, may I read, Lordship? Page number 82, the type copy, Lordship.
Yes.
In last paragraph, Lordship, in view of the above facts and circumstances, as the service of the teachers of petitioners schools have already been provincialized under the provision of the Assam Venture Education Institution Provincialization of Services Act 2011 and amended in 2012. On the other hand, under clause 3(1)(x) of the provincialization of the service of the Act 2017, only 2 teachers or tutors are entitled to provincialize of service against the LP schools. Hence, the claim of the petitioners, Muhammad Safiqul Islam and others, provincialization of the service as third and fourth teachers of the LP schools cannot be considered under the provision of the Assam Provincialization of the Service Teachers Reorganization of Education Institution Act of 2017. Lordship, here we are, our grievance is that the 2011 Act is declared as an unconstitutional due to the contradiction of the RTE Act 2009, Lordship. As per the RTE Act, the teachers pupil ratio should be maintained in the schools, primary schools, Lordship. And in the petitioner schools, there are students' enrollments are shown in the annexure 2, Lordship. We have shown the status of the enrollment of the school, Lordship, petitioner schools, Lordship. At the time of the, all the petitioner schools has been provincialized under 11 Act in the year 2013, Lordship. And at that point of time also, the students' enrollment of the petitioner schools are shown in the page number 39, Lordship, annexure 2.
Okay, let notice go at this is the
Lordship.
Ms. M. Sarma, learned counsel for the petitioner, Mr. Vidya Bora, learned something counsel for the respondent in elementary education department. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 25 5/2/2025, which will get annexure 8, by which the Director of Elementary Education, Assam, has rejected the claim of the petitioner for provincialization of their services. The learned counsel for the petitioner submits that the petitioners have preferred one read petition being WPC number 6703 of 2017. Annexure 3 is the read petition preferred by the
That's it.
petitioner.
Lordship. Annex-
Annexure 3.
Annexure 2 is enrollment.
No. Annexure 3 is the
High Court
Uh,
order dated.
order.
Annexure 6, Lordship. Annexure 6 is the High Court order dated
Annexure?
6, page number 61.
Okay. WPC number 1024 of 2023,
Lordship.
wherein a coordinate bench of this court was placed to direct the respondent authorities to consider the case of the petitioner as per mandate of the provision of the Assam Education with Indicate Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017. If found eligible for the purpose. Thereafter, the respondent authorities have failed to implement the direction issued by this court, for which contempt case number 692 of 2024 has been instituted against the respondent authorities. And during the pendency of the said contempt proceeding, the Director, Elementary Education, has passed the interim order rejecting the claim of the petitioner. Being aggrieved, the petitioner approached this court by filing the present petition. The submission of Ms. Sharma, learned counsel for the petitioner, needs further consideration. At this instance, notice be issued to the respondents, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. Notice of returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by Mr. Bora, learned counsel for the respondents, standing counsel for the respondent. However, extra requisite copy of the petition will be furnished to him during the course of the day. Release the matter after 4 weeks.
Highly obliged.
May I please Lordship. Lordship, petitioner herein Lordship, he was appointed as a lecturer of Bengal College Lordship as a lecturer in Lordship 2004 Lordship. Thereafter Lordship, his post was provincialized and confirmed. Lordship, thereafter what happened? A criminal case Lordship lost against the petitioner and he was convicted and he was suspended Lordship. He was suspended on first suspension order Lordship. Kindly see page 23 Lordship. He was suspended on 25/2021. He was behind the bar Lordship and he was released on bail Lordship thereafter. Lordship, what happened after completion of trial Lordship? He was convicted under section 6 of Poxo Act Lordship. And thereafter Lordship, he filed an appeal before this High Court. And pending this appeal, or during pending this appeal Lordship, he was terminated from his service without any procedure Lordship. His appeal is pending before this honorable court and he was granted bail. Lordship, kindly see the IA Lordship, IA order Lordship. Page 41, Lordship.
No, now what is your grievance?
Lordship, I may be allowed to join in my service Lordship during this pending this appeal Lordship. If appeal is goes against me Lordship, then I have no objection Lordship.
Pardon?
Lordship, during pending if there appeal is pending before this honorable court Lordship, so I may be allowed to join in my service to reinstate in my post Lordship during pending this appeal. Appeal is pending before this honorable court Lordship. I am granted bail Lordship. Impugn order list 41 kindly see Lordship 41. Yes, 41 Lordship. This impugn order, termination order Lordship. Lordship, without any procedure Lordship.
Without any procedure.
Lordship.
Without any procedure.
Yeah, Lordship.
What procedure?
Lordship, I may be department may be terminated from my service if I'm though I am convicted Lordship.
But have you seen there is on provision 311?
Lordship, my simple
Article
prayer is Lordship,
311?
during pending this appeal, I may be allowed to join Lordship.
How? Under what provision?
Lordship, if appeal is pending and there is no order
No,
till date,
you have
Lordship.
already been convicted. Your conviction has not been suspended. Suspended?
Yes, I'm terminated.
No. Your
Initial
conviction
suspended.
is suspended.
Yes, Lordship.
Conviction is suspended or sentence is suspended?
No, sir, not suspended Lordship.
Not suspended.
Conviction is appeal is pending, not final order Lordship. Appeal is pending before this honorable court.
So do you know that when a person is convicted
Yes, Lordship.
of criminal offense, then he is not required to be issued any so-called notice or any other
Terminated
proceeding?
proceeding, not necessary. He may be terminated from his service anytime after conviction Lordship.
Yes.
So my humble prayer is that Lordship, just till the appeal disposed by this honorable court Lordship, I may be allowed to join.
Where it is provided?
There is no provision Lordship.
Where?
Lordship, conviction order not.
Under
filed,
which provision?
but there is no.
Is
provision,
it
Lordship, but-
provided in the service rule? You show me any provision that you were entitled to join during pendency of the appeal.
Lordship. Is there, Lordship,
Can you show?
Lordship, today I have no any instruction, Lordship.
You have no instruction.
Yeah. Can you please any other date, Lordship? I will-
Any other date? Okay. Yes, Mr. Das?
Lordship, notice may go on.
Heard, Mr.
Yes, Islam, Lordship.
Learned counsel for the petitioner, Mr. Estes, learned standing counsel for the higher education department. This petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 3rd of October 2025, passed by the Director of Education, BTC Kukrajar. It is to be noted here that by impugn order dated so and so, the petitioner is terminated from his service. For being convicted for commission of the offense under section
6 of Oxford.
376 within bracket 3 201 306 IPC, read with section 6 of the POCSO Act. The grievance of the petitioner is that without following any due process of law and without issuing any so cause notice, the petitioner is terminated from service. And though he has been convicted by the trial court, he has already preferred one appeal before this court, and the appeal. What is the number of the appeal?
Lordship, 11824. 8/124.
118/2024. And the same is pending for adjudication before this court. And under the aforementioned circumstances, he contended that he may be allowed to join his service. The other hand, Mr. Das, learned counsel, learned standing counsel for the higher education department, submits that the petitioner has been convicted for the offense under section 6 of the POCSO Act.
Yes, Lordship.
6 of the POCSO Act. And as such, without initiating any disciplinary proceeding, he has been terminated from service. Mr. Das further submits that at this stage, notice may be issued, so that the department may file their response. Para. Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the impugn order dated 3/10/2025. Let notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Das. No, 4 is there. 4 is principal.
I'll be paying for 1 and 2 for 3 madam. Is it also there?
Okay. Sir, Das for 1 and 2. Notice, however, no formal notice is required to be issued to the respondent number 1 and 2 since Mr. Das entered appearance and received notice. But extra requisite copy of the petition will furnish to him during the course of the day. Step upon respondent number 3 and 4 be taken by registered post with AD and also by usual process within a week today. List of the 4 weeks.
I'm deeply obliged.
May I please? May I please, Your Lordship? This matter relates to my promotion of the petitioner as head assistant of the Deepu Government College, madam, as well as fixation of his seniority over the respondent number 7, madam. Now, here, my lord, the petitioner was initially appointed as a laboratory assistant in 1995, madam. And thereafter, my lord, he was, what happened, my lord? He was promoted to as UDA on, by the order dated 33/2022. But surprisingly, my lord, what happened, my lord, that one was 7, who is much junior to him. So was upgraded to the post of UDA, my lord, ahead of him, my lord. Then he immediately lost protest before the authorities, and then he was subsequently, after 1 month, he was promoted. So, lordship, in the meantime, he was allowed to take charge of the as head assistant and in charge assistant, my lord, temporarily, but not promoted on regular basis, my lord. Now, what happened, my lord? The authorities are still not have to consider his promotion on regular basis as head assistant, my lord. While this other respondent number 7, my lord, she is also claiming seniority over the, my lord, the petitioner, since he was promoted earlier, my lord. That is the, so his
No,
petition
you
file for
tell
fixing
me,
the seniority.
is there any rule for promoting one laboratory assistant to UD assistant?
Yes, my lord. Rules are there, but most probably my ministerial rules have to go. That some government college ministry stuff rules are is not there, man.
Is it there?
It should be there, man. But here, man, what?
But
Apparently, my
laboratory
her
assistant,
appointment, I have
laboratory-
to annex, my lord, this appointment letter. She was this petitioner was the gradation, as per gradation list, my lord. He is much senior. Gradation list, kindly first, my lord. Go to the gradation at page 44. Yep, it will reflect her.
No,
and,
my question
appointment.
is whether a person holding the post of laboratory assistant
My lord.
can be promoted to the UD assistant.
He was promoted to PD assistant.
Is there any service rule?
Yes, they are same cadres, my lord. With UD, LDA and laboratory assistant are the same cadres, man. That goes.
Yes, madam, any service rule on this point?
Lordship, it is the same.
They are the same cadre, madam.
Okay.
That at page 44 is annexed.
Let notice go at this instance.
At this notice been provided.
Heard, Mr. Hazarika,
IA Hazarikan.
learned counsel for the petitioner. Ms. Kemper for respondent number 225, Mr. Das for what? Respondent number 12. The petitioner herein has challenged the order dated 25th of February 2022 and the promotion order dated 1/3/2022, whereby the respondent number 7 was promoted as UD assistant of Deepu Government College. And also right for issuing direction to the respondent authorities to promote the petitioner as head assistant of Deepu Government College as per recommendation of the DPC dated 30th/10/2024. The learned counsel for the petitioner submits that the petitioner is senior to the respondent number 7 as per gradation list, which is being enclosed with the petition as Annexure K at page number 44. And despite the respondent authorities have promoted the respondent number 7,
College authorities, man, not school.
college authorities have promoted the respondent number 7 as UD assistant. UD assistant without considering the case of the petitioner. Petition. And The Karbi Anglong Autonomous Council Authority has approved upgradation of service of the respondent number 7 to the rank of UDA by order dated 25/2/2022. Subsequently, the Karbi Anglong Autonomous Council Authority approved the upgradation of the service of the petitioner from the post of laboratory assistant to the rank of UDA by order dated 38/3/2022 issued by the Additional Director of Education, Karbi Anglong Autonomous Council. And thereafter promoted the petitioner to the post of UDA on 31st of March 2022, issued by the Principal Diffu College, Diffu Government College. Thereafter, the petitioner has requested the authority to give effect of the promotion prior to respondent number 7. And he has been assured that his case would be considered in the subsequent promotion. Thereafter, the principal of Diffu College written a letter dated 4/10/2024 to the Secretary Education, which will make it higher, Karbi Anglong Autonomous Council, stating that as per gradation list prepared on 4/2/2024, the petitioner joined as laboratory assistant on 7/2/1995. And the respondent number joined on 8/1/2004. But the name of the respondent number 7 was mistakenly forwarded by the then in charge principal for promotion. Thereafter, the DPC meeting regarding the promotion of UDA to the post of head assistant in respect of Diffu College was held on 30/10/2024. And the DPC has recommended the name of the petitioner for promotion to the next higher rank of head assistant against the resultant vacancy. With effect from 31/10/2024. Accordingly, by order dated 30/10/2024, issued by the principal in charge Diffu College, the petitioner was temporarily allowed to hold the search, take the search from one Doheswar Doimari with immediate effect until further order. But the respondent number 7 has challenged the order by filing one writ petition being WPC number 2237 of 2025, which is pending before this court for adjudication. And since the respondent number 7 was promoted by the respondent authority to the post of UDA, by order dated 1/3/2022, she has been claiming for promotion to the post of head assistant on the basis of impugned orders dated 25/2/2022 and 1/3/2022 arbitrarily, and being aggrieved, the petitioner approached this court by filing the present petition. That writ petition is still pending.
Pending, let me tag along with that one, madam,
Okay.
because otherwise there'll be conflicting orders, madam.
The submission of Mr. Hazarika needs further consideration at this basis. Notice be issued to the respondents. Returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, 2, 3, 4, 5. 5 and
Higher
6,
division.
since they are represented by their standing counsel. But extra requisite copy of the petition will be furnished to them during the course of the day. Step upon respondent number 7 be taken by registered post with ADN also by usual process within a week from today. List after 4 weeks. Registration list, take this matter along with WPC number 2237 of 2025.
So Lordship, pendency of the matter may not be bar may consider a representation of the petitioner which is pending, my lord. At 12, annexure which
Okay,
filed dated
the learned counsel for the petitioner also suggested the petitioner has filed one representation dated
12/11/2025, ma'am. Annexure and page 48.
12 November 2025 and the same is yet to be disposed of by the respondent authority. It is being clarified that pendency of this petition would not be a bar for the respondent authority to consider and dispose of the representation filed by the petitioner.
Much obliged.
Authority verified the documents, lordship. After issuing the OM, lordship, page 30, lordship. Letter issued by the.
But you say
Serial number 32, lordship. My name appeared serial number 32, lordship.
the government has already taken a decision.
Thereafter, I have submitted required particulars also, lordship.
No, now the government has taken a decision
Lordship.
not to place the cases of the petitioners whose cases were not pending before disposal of the earlier petition in the month of April.
Lordship, that was clear. Another coordinate bench, lordship. Lordship, kindly peruse. Page 50, lordship. Start from page 50. Relevant page 52, lordship. Last 3-4 line, 52, first para, last 3-4 line. However, subsequently, this code in WPC number dated 4/6/2020 has observed that consideration should not be limited to only those cases which were pending as on so-and-so, the ends of justice, and having regard to the observation made in paragraph 910 of the order dated 3/4 so-and-so in WPC number so-and-so. That was cleared.
Your pair is to pass similar order
Yes, sir.
like this 13/10/2025.
Lordship.
Mr. Peko, you have gone through this order.
But the petitioner has submitted an application in terms of the notice, my lord. Within the time 59. You can send it, remand it back to the committee, my lord. I think dispose it of in accordance with law.
Lordship. Page 49, lordship application.
We are putting one, right?
Okay, we will pass similar order then.
Lordship. Obliged, lordship.
Item 6.
Please, your lordship. My lord, here the petitioners are the applicants for compassionate appointment, my lord. Initially, my lord, earlier their cases were not placed before the DLC. So they approached this honorable court by filing various writ petitions. And this honorable court, my lord, directed to place before the DLC. Accordingly, their cases were placed before the DLC and the DLC recommended their cases, my lord, for placing before SLC, my lord. So in the meantime, the office memorandum, the 18/9/2024 came in. So thereafter, series of writ petitions were filed and an order was passed on 3/4/2025, my lord. So after that, my lord, the petitioner filed writ petition before this honorable court
by challenging the same OM, my lords. And in their cases, my lord, this honorable court filed, my lord, passed several orders, my lord, for placing before SLC. These are E series, my lord. I start from page 73, my lord. In all these cases, there are directions of
Let
this.
notice go, in the meantime, she will obtain instruction.
My lord, the petitioners have already submitted their applications, my lord, as per the, in terms of the notice, my
But
lord.
the government has
And
taken,
then,
already
uh,
taken a decision.
Their applications are, my lord, pending before, my lord, the authorities, my lord. My humble prayer is that, my lord, since there is a direction of this honorable court to place before the SLC, and already they have submitted applications, my lord, as per the notice, my lord, dated, my lord, my lord, it is at page 104, my lord. 104. Notice dated 30/8/2025. In format they have submitted, my lord. So, my lord, my humble prayer is that, my lord, their cases may be considered and placed before the SLC, since there is already direction of this honorable court for placing before SLC, my lord. The applications I have annexed as annexure G1 for G series, my lord. Because the SLC may sit any moment, my lord. So their names can also be included in the SOP, because they have also challenged the SOP, and there are directions from this honorable court to place before the SLC, my lord. The respondents cannot do not have the authority, my lord, to choose as to which order they should follow and which order not, because all are orders from this honorable court. Annexure E series, my lord, clearly says that
Maybe,
the direction to place before the SLC.
let her obtain instruction. Heard, Miss
And
SB
in the meantime, SLC may also sit. So, my lord, there may not be any bar to
no, no.
consider the cases of the petition.
Okay.
Yes, my lord.
Heard, Miss SB Chaudhary, learned counsel for the petitioner. Miss K. Fokon, learned standing counsel for the respondent. Respondent number? All the respondents, for all the respondents. This petition under Article 226 of the Constitution of India, the petitioner has challenged the clause number 4 of the decision of Chief Secretary's 13th monthly review meeting with senior most secretaries, which was communicated to the senior most secretaries to the Government of Assam, all administrative departments, Dispur, and to district commissioner of all the districts, right? Official communication number ECF.7214/2019 dated 15/11/2025, issued by the secretary to the Government of Assam, Personnel B Department, Dispur, Guwahati 6. And also to direct the respondent authorities, more particularly the Personnel B Department, to modify, to alter the clause struck paragraph 4 of the minutes of the meeting dated 1/11/2025 with regard to the compassionate appointment, and include the name of the petitioners in the SOP for being appointed on compassionate ground. As they are equally entitled to entitled for consideration by SLC, whose cases have been directed by this court to be considered after 3/4/2025. Where is the petition and the documents placed on record? Let notice be issued to the respondent. However, no formal notice is required to be issued since Ms. K. Fukun, learned standing counsel, learned government advocate, entered appearance and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. List the matter after 2 weeks. In the meantime, Ms. Fukon shall obtain necessary instruction and apprise this court on next date. List the matter on. Yes, first week January.
My lord, pendency of this matter.
Yes,
should not-
it is, however, provided that pendency of this petition would not be a bar in placing the case of the petitioner before the next available SLC.
Offline, my lord.
My lord, I'm appearing for the petitioner.
Yes.
Petitioner is was an associate professor at the Royal Global University Law Department, and she is an international reputed scholar. Now, on 25th of October, she was terminated, and the termination is retrospective from 17th of October. However, this termination letter entirely speaks of terrible things about her, such as open defiance, argumentative conduct, and insubordination. It also notes that they had asked her to resign, however, she did not, and therefore she is being terminated. Now, the procedures established by the UGC, the University Grants Commission, and through the UGC, the university as well has a very clear grievance redressal procedure, which is, you should notice, you have a committee and the person presents themselves, they give their defense in writing, and then there is a finding. Basically, an odi altrum partum process, fair and transparent manner, which has not happened despite
Madam,
repeated.
first you tell me, this Royal Global University is a
Yes.
private university.
Yes, ma'am.
Whether this petition under Article 226 is maintainable?
Yes, my lord, because they are
How?
they are recognized under the University Grants Commission, and they fall under Article 12 of the Constitution because their rules and all their reportings go to the University Grants Commission, my lord. And also they perform the public function of imparting education, including granting PhDs. The petitioner is one of the PhD guides in the university, my lord. And all the rules that we are citing are University Grants Commission rules. Even within the university rules that we are citing as being violated are drawing their inference from the University Grants Commission. So this is entirely public in nature, my lord.
No, madam, there are some decision of the Supreme Court where it is stated that they are not the state within the meaning of Article 12.
My lord, the decisions that I have looked into say the contrary. We have also cited the Supreme Court decision, which is the Kalyan Mativanam versus KV Jayaraj, which affirms that UGC regulations are mandatory for UGC recognized universities, and therefore they fall under Article 12 of the Constitution of India. And
Okay,
that is why
produce that decision, then we will see. Let it be on Monday, next Monday.
the 15th, upcoming Monday,
Yes,
my lord,
you produce the relevant decision, we will see.
my lord.
Heard, miss, your good name, please.
Ujjaini Chatterjee.
Learned counsel for the petitioner. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 25/10/2025, by which the petitioner is terminated from her service by the respondent, Assam Royal Global University. Registrar shall list the matter on Monday so as to enable the learned counsel for the petitioner to satisfy this court regarding maintainability of this petition against a private university, that is the Assam Royal Global University.
My
List
lord, if you
accordingly.
wish to pass this over to a maybe post lunch, I could arrange the orders by then. I mean, the judgments by then, and cite it before you if that saves time of the court.
Okay. Okay.
Shall I do that?
Today.
No, at 2 p.m. on Monday.
Okay, at 2 p.m. on Monday. Okay.
2 p.m. on
2
Monday.
p.m. Yes.
All right. 2 p.m. Monday.
I don't care.
Please, your lordship, the matter relates to the provincialization certificate officer. It was recommended by the district scrutiny committee, then state level scrutiny committee, and his case was examined by the independent authority, lordship. Thereafter, lordship, kindly see the annexure 7, page 53, lordship. Lordship, this is the letter submitted by the director to the respondent number 1, lordship. Wherever lordship submitted 63 numbers of incumbents whose service is to be provincialized, lordship. And petitioner name is appeared in serial number 53 and 54, lordship, page number 65. With a specific view that may be considered for provincialization. Page number 65.
Okay, let notice go.
Yes, lordship.
Heard Ms. Soria, learned counsel for the petitioner. Ms. Peters, learned standing counsel for the respondent in
One
secondary
page.
education department. The petitioner hearing have challenged the order dated 25/9/2025 by which the claim of the petitioners for provincialization of their service was rejected. The learned counsel for the petitioner submits that the name of the petitioners were recommended by the District Scrutiny Committee under the Act of 2017.
Number 2, petition. 7.
But whether it was placed before the state level committee,
Yes, lordship.
when?
Everything was done, lordship.
Independent authority,
Thereafter, in pursuance of the honorable court's order, their case was again placed before the joint committee, lordship. That is annexure 11.
Placed before independent authority.
Annexure 11, lordship. In Annexure 11, resolution number 2, lordship. That's page 84. Their case is again.
The case of the petitioners were placed before the SLC, state level committee, and the state level committee has recommended your case.
Yes, lordship. Is it annexure?
Page number?
It is a letter, lordship. Annexure 4, page 44, lordship. It's a letter issued by the director in second last paragraph, lordship.
The state level scrutiny committee has recommended the name of the petitioners for provincialization of their service under the Act of 2017 and submitted to the government for according approval. Pursuant to the order passed by this court in WPC number 4992 of 2021. But the matter was thereafter placed before the joint committee, and the joint committee has rejected the claim of the petitioner.
As
Being
your
active, the
lordship-
petitioners approached this court.
Annexure 11, your lordship. Resolution number, your lordship. Paragraph or your lordship. I would like to draw your attention.
But madam, please don't disturb while I'm dictating the order. After dictation, you can make any clarification you want, but not at the time of dictation of the order. The submission of learned counsel for the petitioner needs further consideration. At this stage, notice be issued to the respondent, returnable in 4 weeks. However, no formal notice is required to be issued. Since all the, who is for deputy commissioner? You. Ms. Kepukon for deputy commissioner. Since all the respondents are represented by their standing counsel, but extra requisite copy of the petition be furnished to them during the course of the day. Lays the matter after 4 weeks. In the meantime, the respondent authorities shall file their affidavit in opposition.
Incomplete writ petition has been furnished.
I will serve Lordship, yes.
On the page 83, I got this writ petition. Thereafter also.
Okay, so you will furnish.
Yes.
What dear sir?
My lord, in this case, my lord, this writ petition is filed on the, my lord, second round of the writ petition, my lord, actually, my lord. There, what is happening in earlier writ petition, my lord, petitioner paid for, my lord, pension and retirement benefit after the death of her husband, my lord, who was a employee teacher, my lord. Some communication letters were, my lord, there, my lord, between the parties, my lord. I want to place the said papers, my lord. First time I want to, my lord, place annexure, my lord, that is kindly peruse your lordship, annexure 17, page 59, my lord. Original copies, my lord, also here. Submission of pension case in respect of the Basanti Mujumdar. Page
But
61, my lord.
why you could not file the pair within the stipulated time?
Oh, yes,
Why-
my lord.
why-
There was some delay, my lord.
Why?
But they have, there was delay because, my lord, there is nothing was, my lord, dear, my lord, communication, my lord, and petitioner also did know, my lord. So, my lord, on that issue, my lord, already that has been mentioned here, my lord, in the letter, my lord, because there is some provision, my lord, in the pension rule 2005 and 2006, my lord, relaxing the, if petitioner prays for, my lord, from today, my lord, or not, she will able to get benefit from today itself, my lord. This relaxation is also there. They have also already mentioned in the letter, my lord, in earlier communication letter. Can you peruse your lordship, my lord, page 64, my lord. Followed by the Honorable Court Sodarmala in earlier, my lord, with reference to the subject cited above, I am to inform you that the family pension proposed in respect of Basanti Mujumdar, wife of Narayan Chandra Mujumdar, ex-assistant teacher Vivekananda ME School, has been submitted to the director of after a lapse of 40 years from the date of the pensioner. Hence, you are requested to move in the government ARCP and PG department for relaxation of the Rule 205 and 206 of Assam Services Pension Rule 1969, my lord. Thereafter, my lord, next letter issued, it was, my lord, written by the, my lord, Joint Secretary regarding mentioning that relaxation of Rule 2005 and 2006, my lord. With reference to the subjects, type copy is also here, my lord. I have a next, that is page starts from, my lord, 65. Along with the enclosures original, and request you to resubmit the same in prescribed format to an investigative department. Next, my lord, letter, my lord, issued, and look where is your lordship, that is page 70. It was Joint Secretary wrote to the, my lord, Joint Secretary to the Government of Assam, ARTPPG department. Issued on, my lord.
Let notice go at this stage.
Lordship?
Let notice go.
Yes, my lord. Subsequently, my lord, last letter issued in the year 2025 itself, my lord. Last letter I want to place, my lord. Kindly peruse your lordship, page 77.
No, Mr. Das, you see here, the
Page
director
77
of
only.
pension
Last,
has, the director of pension has returned the pension papers.
yes, my lord. To the inspector of the school. So, my lord, next turn is the inspector of the school. If she submits the papers,
Inspector
my
of
lord,
the
she will be
school,
able to get.
Inspector of school cannot do anything.
No, my lord, she has to submit the, my lord, the relevant papers after relaxation of the said, my lord, concept. Here it is specifically mentioned, my lord. Now, in
Mr. Das, Have you gone to page number 63? The last part of the letter?
63. Yes, my lord.
Read it.
Yes, my lord. 63. Hence, you are requested to move in the government in ARTPG PG department for relaxation of the rule 205 and 206 of the Assam Service Pension Rule 1969. Pension proposal in original return is returned
Okay,
herewith for
alright.
your information and
Okay,
necessary.
okay. But have you implemented this ARTP and PG
Do not
department as party in this proceeding?
This party is already here, my lord.
Where?
Uh,
Where?
that earlier occasion, my lord, when earlier proceeding, my lord, when it was moved, my lord, that was not raised, my lord, regarding the implementation of this.
No, now the
party.
matter will go to this department, and this department is not a party in this proceeding.
If necessary, my lord, I can implement, my lord. Otherwise, my lord, last letter, according to last letter, my lord.
No, unless the delay is condoned, then the inspector of school would not be able to do anything.
Yes, my lord, then I can implement.
Part Mr. Das, learned counsel for the petitioner. Ms. Kemper for the respondent in. Respondent number 3,
3, 6, 8, Lord.
3, 6, and 8. And respondent number 4. And Ms. Pukon for respondent number 5. Director Elementary Education, Mr. Pegu. Mr. Pegu. Mr. Das, learned counsel for the petitioner, submits that the pension paper of the petitioner was returned by the director of pension to the inspector of school, Karbi Anglong District Circle Depot, with a request to move the government in ARTP and PG department for relaxation of Rule 205 and 206 of the Assam Service Pension Rule 1969. But said department is not allied as a party in this proceeding. Mr. Das submits that he may be granted some time to file application for implementing the said department as party in this proceeding. Parallel, recusal is the matter immediately after reopening of the vacation.
I will ask, my lord.
May I please, your lordship?
Yes.
My lord, the petitioner is now been serving as a principal tutor, my lord, in Hamidabad College in the district of Dhubri, my lord. My lord, the main grievance of this present petition is regarding the departmental proceeding, my lord, which had been initiated against the petitioner, my lord. My lord, I am not evading or escaping from the departmental proceeding. My only limited grievance, my lord, is that as there is a procedure prescribed under the law, my lord, my lordship knows that the Rule 6 and as well as the Rule 7 and 9 of the Assam Service Discipline and Appeal Rules is connected with the present set of employees, my lord. But my lord, they have totally in violation of the procedure prescribed, they have initiated the departmental proceeding, my lord. That is the grievance. Now, initially, my lord, I beg to draw my lordship's attention, my lord, to the order of my suspension. My lord may be pleased to find is at page
You are
35.
still under suspension.
Still under suspension, my lord. Still under, my lord, once suspended, I was reinstated, my lord. Now, just basing on a complaint by the, my lord, president of the governing body college, my lord, again I have been suspended, my lord. On the ground that as I have been arrested, it was not informed to the governing body. So therefore, the governing body write a, my lord, complaint
to the Milord Director of Higher Education, and acting on that complaint, I have been subsequently suspended. And Milord, a second departmental proceeding on a same set of allegation, Milord, had been initiated against me, Milord. Now, Milord, they are now going to punish me for the same offenses twice, Milord. That is their intention, Milord. From this array of, Milord, this sequence of events, Milord, gives the indication of that nature, Milord. My lord, just for a moment, my lord, this is my, at page 35, Annexure 2, my lord, is the initial order of suspension as per the Rule 6(2) of the Assam Service Discipline and Appeal Rules 1964. Dr. Sahadat Ali, tutor principal of Hamidabad College, so-and-so is hereby placed under suspension with immediate effect as he is detained in police custody for more than 48 hours. My lord, there is a false criminal case had been lodged against me, my lord, and basing on that, I had been arrested. And basing on, my lord, deemed suspension provision, this order had been issued. Now, my lord, thereafter, my lord, at page 36, my lord, is a order for which this departmental proceeding has been initiated, my lord. Dr. Sahadat Ali was by order number is hereby. My lord, may kindly see my reinstatement order. Is that at the very next page, page 36, Annexure 3. Pending Royal so-and-so was placed under suspension by the order number dated 21/10/2024 is hereby reinstated in his service with immediate effect. However, so-and-so is entrusted to hold the charge of DDO Hamidabad College until further order from this directorate. So, my lord, from this order, it reflects that I have been only given the academic charge, my lord, not the financial power. Now, my lord, when I was, my lord, just reinstated, my lord, kindly note the date. It is on 4th of April 2025, my lord. And on that day, the, my lord, the governing body president, my lord, lodged a complaint at page 37, Annexure 4 to the Director of Higher Education Assam, so-and-so. With reference to the subject cited above, I state that tutor principal Dr. Sahadat Ali of Hamidabad College, so-and-so, was arrested on so-and-so by the Chief Minister's vigilance cells, but the said Dr. Sahadat Ali kept it sacred and not informed in written to the governing body of the college. This is a gross violation of the service rule. Hence, I highly request to take necessary action as per the rules of the land. With thanks. Basing on this complaint, subsequently, my lord may be pleased to find page 40, my lord. No, suspension order, the second suspension. My lord, I am sorry, my lord. Kindly turn to page 58, my lord. This is the order by which, my lord, I had been again, my lord, placed under suspension, my lord. Whereas a complaint was received on 4/4/2025 from the president of the governing body of Hamidabad College, so-and-so, tutor principal Hamidabad College, where an inquiry team was constituted by letter number dated so-and-so into the matters and collect necessary evidence as part of a fact-finding exercise. The inquiry team reached the Hamidabad College on so-and-so and submitted a report to the undersigned on 8/4. As per the inquiry report received on, the inquiry team could not complete the inquiry due to the disruption caused by commotion in the Hamidabad College campus, whereas Mr. Ali so-and-so, instead of extending cooperation, repeatedly instigated or facilitated the gathering of a large and unruly crowd within the college premises, thereby severely obstructing the process of inquiry and vitiating the academic atmosphere of the institution. And whereas the such conduct amounts to interference with the official proceedings, a breach of conduct expected of a public servant, and a potential threat to the maintenance of the public order within an educational institution. Now, therefore, in exercise of the power conferred under so-and-so, is hereby placed Mr. Sahadat Ali, tutor principal of the college, with immediate effect pending disciplinary proceedings. So, my lord, this is the second order by which I had been placed under suspension. And, my lord, again, a second proceeding had been initiated basing on the same set of allegations, my lord: corruption, mismanagement, mishandling. So, my lord, our limited, my lord, grievance in this petition we have prayed that, my lord, if any subsequent charges has been developed, that can be, my lord, can be a part of the original charge memo, my lord, they can add. Now, my lord,
How?
but there is a, my lord, under the Service Discipline and Appeal Rules, my lord, 1964, the charges which has been established, my lord, that proceeding has not yet been culminated, my lord, still pending. So
No,
the
subsequent events are quite
subsequent events
different.
are, my lord, the original events, my lord. Now, my lord, multiple affairs are being lodged, my lord, basing on a same set of allegations. Now, the learned court below, my
No,
lord,
here the allegations are quite different.
no, my lord, what has happened, my lord, the allegations, they have said it is arising out of the original allegation, my lord, that is their stand. They have said that when the inquiry team went there, I have, my lord, invited the gathering and caused disturbance to the inquiry, my lord. That is the allegation, that inquiry is,
So how this allegation is connected with the other allegations?
my lord, the original allegations, my lord, which has been there, is being inquired on by the inquiry committee. Now, when the inquiry committee went there, my lord, they have said that I have obstructed and caused the disturbance.
How can this be a double jeopardy as contended by you?
My lord, because the original, my lord, charges which has been
No,
inquired into,
second
my lord.
charge is completely different.
No, my lord, if my lord may be pleased to peruse the charge memo, both the charge memos, my lord, which is there, my lord, I have annexed the first charge memo, my lord may be pleased to find. At page 40, my lord, annexure 6 is the first charge memo dated 4th of April 2025, my lord. Therefore, you are charged with, my lord, I am reading the middle part, charges indulging in corruption, financial misconduct, violation of the official discipline and decorum, thereby causing embarrassment to the government, which is very unbecoming of a government servant. During your tenure, you have not maintained the stock registers and you have submitted a fake vouchers oblique bills showing the my lord, purchase of a different materials, particular, etc. So, charges, you are charged with the misappropriation of the government fund, financial misconduct and violation of the integrity of office. You are to submit your reply to the undersigned within 7 days, positively from the date of receipt of this letter, failing which the necessary action will be taken against you. Now, my lord, herein they have said that the witnesses and the list of documents they have mentioned. But, my lord, unfortunately, neither this list of documents had never been supplied to me, my lord, never been a part of this charge memo, which, my lord, I have raised the objection before the authorities. But, my lord, by my lord, overriding those, my lord, my objections, my lord, they proceeded with further with this departmental proceeding, my lord. And therefore, the inquiry team had also been constituted. Inquiry had also been conducted, my lord, wherein some contradictory report has also been
No,
arrived.
this annexure 13 is the second Sokos.
Second charge memo at
So,
page 72, my lord.
Going by this charges, can
My
it
lord.
be said that they are similar?
No, my lord, I am not saying that, my lord, exactly similar. But, my
Then-
lord, my respectful submission before my lord is that, my lord, what has happened, my lord, while the original charges are being inquired into by the inquiry committee, they have said that I have obstructed. Now, this subsequent event, my lord, arising out of the original sequence of events, my lord. Now, this second, my lord, if now and now again a third sequence of event arises, my lord, in near future, they will again initiate a third charge memo. So that is their intention, my lord. So that they can club all these things into one, my lord, and can proceed, my lord.
No, that cannot be.
Huh?
That cannot be.
Now, my lord, this is one aspect and one limb of my argument, my lord. And the second limb of my argument, if my lord, if I cannot satisfy my lord, that my lord, that the second charge memo is identical and different, my lord, they can proceed, my lord. They can proceed also with the second charge memo.
No, this is going by this second charge memo.
My lord.
How can it be said that they are identical with the first one?
No, my lord, I am not saying that exactly identical or same set of nature of, my lord. My submission, my lord, is that the second sequence of events, my lord, which has arisen, is a foundation arising out of the first charge memo, my lord.
Mr. Bhuya, you see,
My lord.
if you disturb the inquiry committee, then dispensing with the inquiry, they can take resort to Article 311 proviso to Article 311(2).
My lord, my lord.
They
Yes, my
can,
lord, they
without
can.
any inquiry, they can terminate you from service.
For disturbing them, my lord.
Yes. Yes.
My lord, it is their allegation, my lord, that I have invited the connotation on that day, which is absolutely incorrect. my lord.
Maybe. They may record it in their file and they can terminate you from their service, from your service.
My lord.
This has serious implication.
No, serious implication is there, my lord, but the issue is that if we go by the second search memo, my lord, the search memo is incomplete. We have
Maybe that is a different aspect.
no, my lord, that's why, my lord, I have initially, while I started my submission, my lord, I have respectfully submitted, my lord, that I am not avoiding any disciplinary proceeding, my lord. I am always subjected to a proceeding, but that proceeding should be in accordance with law, my lord. Now, that procedure prescribed under the law, they have not followed, my lord.
How they have not followed?
Yes, yes, if my lord may be pleased to find the second search memo, my lord, page number 65, my lord.
Yes.
Now, my lord, in this case, if they have, my lord, issued this show cause along with the charges, this, my lord, list of documents, my lord, which they have relied on, is now missing here, my lord.
Whether you have filed any application
Yes,
before
yes, my lord, we
the
have,
disciplinary
after
authority?
this, my lord, I have, নিজে কৈছিলো, কোৱা নাই বুলি যে document খিনি। Written. My lord, to this second search memo also I have replied. Started page 67, my lord.
No,
My lord, may kindly turn
show
to.
me the document by which you
Yes,
have
yes, yes,
asked the
yes, yes, my lord.
disciplinary authority to furnish the
My lord, may
relevant
kindly
papers.
turn to annexure 21, my lord, at page 96, my lord. Application can open. My lord, this is a mail I have given, but the original mail, my lord, I could not annex, my lord. It can be to the,
So one disciplinary proceeding has already been completed.
no, my lord, that disciplinary proceeding.
This inquiry report has been submitted.
Inquiry report,
Annexure
has been-
20?
yes, my lord, that has been submitted. But it has not been, my lord, after the inquiry report, they have not proceeded further, my lord. Even, my lord, my reply to the, after the inquiry, my lord, second show cause is required to be issued, that what punishment they are going to be inflict or what decision they are going to be taken up basing on this inquiry. They should ask a second show cause, my lord, that has also not been issued, my lord, but I am still under suspension. Now, my lord, the second charge memo, I have, my lord, objected by this mail, my lord, at page 96.
But your mail is incomplete.
But, my lord, that mail part is not here, my lord, but this
You
only
produce this document.
my lord, I can, my lord.
Heard Mr. Ayer Bhoi,
Yes,
learned
yes.
counsel for the petitioner. Mr. S. Das, learned standing counsel for the respondent in Higher Education Department.
for 1 to 2, page 4, 1 to 3, 4, my lord.
1, 2, 3, 4.
Yes, ma'am.
3, 4.
Drafting kone kare. Drafting kone kare.
The petitioner herein is aggrieved for initiation of 2 disciplinary proceeding against him by the respondent authorities on identical charges. Mr. Bhuya, learned counsel for the petitioner, submits that in the second disciplinary proceeding initiated against the petitioner, some of the documents have not been furnished to
My
him.
lord.
Where is the second show cause notice? Page
My lord,
number?
it is at page 65, my lord.
65.
My lord.
Yes.
Allegation আহিছে, charges আহিছে, witness, list of documents to the other দিয়াই নাই। On the face of the, my lord, charge memo itself reveals.
No, here, there is no reference to any document that they have relied upon.
My lord,
So
but they have to.
what document,
They
what
have to,
document
they,
you require?
because, my lord, it is the mandate of the rule, my lord. They have
No,
to,
if there is no document to prove the search, then
some complaint or some nature that, what type of, my lord, maybe there, my lord. Basing on some, now basing on what
no,
they have proceeded.
Mr. Bhuya, you see, there is no reference
Hmm?
of any document in this so-called notice.
My
It
lord,
means
if I,
that they have not relied upon any document.
no, my lord, if I may be permitted to read over, my lord, in a, it is reported that a complaint dated 4/4/25 was received from the president of the governing body
Hmm.
of Hamidabad College, alleging the irregularities by you. Accordingly, an inquiry team was constituted so and so to conduct a fact-finding exercise at Hamidabad College and gather necessary evidences. So, my lord, this inquiry committee or this complaint may have been with them, my lord.
That is the earlier documents.
No,
Documents in the earlier departmental.
that's why, my lord, that earlier document is connected with this. They have made a connection with the earlier with the present one. my
That's
lord.
all right, but here they have not relied upon any document.
But, my lord, these documents they have never furnished to me, my lord.
That is in the earlier disciplinary proceeding.
We have objected to that also, my lord.
Hmm.
My lord.
Mr. Bhuya, learned counsel for the petitioner submits that in the disciplinary so-called notice issued in the second disciplinary proceeding dated 3/5/2025, there is reference to some of the documents and by email dated 11th August 2025, the petitioner has requested the director higher education Assam to furnish the relevant papers, but he has not been provided with those documents. But it appears from the email at page number 96 and Annexure 21 that the said email is incomplete. Mr. Bhuya submits that he may be granted some time to produce the original email before this court. There is allowed recess or list the matter on after vacation.
My lord.
After vacation. List on.
10th, my lord.
From 19.
My- Obliged.
My lord, item number 13, 14, 15, similar, my lord. My cases, our cases have been recommended by the DLC in terms of the honorable court's order, and pursuant to the government notice, we have submitted the particulars before 15/9/2025. They have accepted, they have acknowledged. Matter is pending before the SLC. Only for, since we have not challenged the OM, they are reluctant to consider our case. my lord. Almost item number 5 also, you will lordship has passed.
Item number
5, please, my lord. Almost similar, my lord. That is also our
yes,
case also.
Mr. Pego.
But can dispose of my things they have participated in accordance with law.
13, 14, 15. 15. Plus.
My lord, item number 16 and 17, paying for time being.
Item 18.
Covered matter of claiming arrears salary. 82 is the order. Only disposal of representation verification has been given to this one. 18 and 19, but only difference, Lordship, is that they are widows of the two teachers. Page 4, Lordship, we have given the details. Ajia Begum, wife of late and Sida Begum, wife of Abdul Motin. He also earlier preferred repetition. Madam, no, please.
Yes, madam. Similar order. Similar order.
It is there in the similar order that verification would be done. Para 10.
Okay.
At page 84.
Item 19.
Similar matter. The difference is that they have not earlier moved up Honorable High Court. That is only the difference. Otherwise, the legal issue is similar. Deeply.
Item 34.
May it please your lordship. So this is a contempt petition, lordship. At this stage, notice may go, lordship.
Where is the order?
Lordship, at page 13, lordship. Paragraph 4, lordship. Page 13, paragraph 4, lordship. As per the instructions, lordship. So on the basis of that instruction, lordship, this was disposed of, lordship.
Heard Mr. Bordoloi, learned counsel for the petitioner. This contempt proceeding is initiated by Sri Balindra Borwa under section 11 and 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India, and the rules framed under the Guwahati High Court rules for willful and deliberate violation of the order dated 12/8/2025, passed by this court in WPC number 2703 of 2025. Peruse the petition, the documents plus on record, and also peruse the order dated 12/8/2025. Let notice be issued to the contender, returnable in 4 weeks. Four weeks or 2 weeks?
Lordship, 2 weeks, lordship.
2 weeks. Step be taken upon the contender within 3 working days from today
Lordship.
by registered post with ADN, also by usual process within a week from today.
Lordship.
Additionally, dusty service is also permitted. Lays the matter after 4 weeks. Oh, no,
Lordship.
2 weeks.
Lordship.
2 weeks.
Oblige your lordship.
May it please your lordship. Lordship, the instant I has been filed to amend the prayer portion of the writ petitions. Lordship, kindly come to the page number 8, prayer number 3. Lordship, the second half para should be truly read as the prayer portion of the writ petition, instead of the first para.
Third miss. Your name,
D person.
learned counsel for the applicant. And miss, your name? Order Soitia, learned counsel. Appearing on behalf of SK Mehdi, learned standing counsel for the respondent number 7 in the writ petition number 66662 of 2025, and Mr. Tobilder for has spoken for respondent number 1 and 4. You are for 3. Director of, okay, 4. 2, 5 and 2, 5 and 6. 2, 5 and 6. You have received the copy of this IA? You received the copy of this IA?
Okay, our name has not been shown actually in the post list, so we have not gone through that.
No, but have you received the copy of IA?
I know, not even petition also received. No, receipt, I am received. Our name has not been put in the.
Oh, in the area that way, this interlocutory application under Order 6, Rule 17 of the Code of Civil Procedure is preferred by the applicant seeking amendment of the pair portion of the writ petition. Mr. Tobilder, learned counsel for the Higher Education Department. You have received the copy? Copy of IA?
No, I have not received the one.
Mr. Tobilder submits that he has not been furnished with a copy of the interlocutory application. Accordingly, learned counsel for the petitioner is directed to furnish a copy of the interlocutory application to Mr. Tobilder during the course of the day, and recess shall list the matter on Monday.
Our name may be reflected in the higher education department.
Okay, recess shall also reflect the name of the standing counsel for the Higher Education Department in the cause title. Oh, no, sorry, in the cause list.
Item 36.
Lordship, this matter may be taken up after some time, Lordship.
One aspect is the lordship, this is bench, otherwise bench three letter lordship.
Wednesday.
State, Union of India is DSF service vessel lordship. It is bench three otherwise.
Okay. Heard, Mr.
You go, Lord.
Learned counsel for the petitioner, Mr. Chakraborty, learned standing counsel for the respondent in BSF. Mr. Chakraborty submits that this matter pertains to bench 3. Accordingly, it is provided that recess shall list the matter and No, rest shall examine the matter and list the same before appropriate bench.
Are the numbers 37 and 38?
May I pray for taking up this matter Monday? For Monday.
Monday,
To complete my instruction as per your lordship's order 8/12/2024. Lordship wanted a clarification.
Yes,
Why the
yes.
Joint committee
Yes,
has said that in district scrutiny committees, minus does not have the date method. We have called for, that report has to be called from the joint committee.
okay.
Monday will be.
Lordship, in the meantime, Lordship, my interim prayer may kindly be considered, Lordship.
On Monday, we'll consider.
Lordship, only thing is that.
Today is
Lordship,
Friday.
No, today. Monday, senior banks has been declared. Soddokate jabo. Monday,
Lordship, kindly, Lordship, the matter was listed on Monday, Lordship, then Wednesday, then today, Lordship. 3 consecutive, Lordship, time matter has been listed,
no,
Lordship.
that's all right, but unless
Lordship,
the.
my only
instructions are
prayer
made
is that,
available.
Lordship, the impugn committee, impugn resolution may kindly be stated, Lordship. Otherwise, I will have
That will
to
serve no
again
purpose.
wait.
Even the resolution is stayed also, their provincialization is rejected. Lordship will take
No,
a
no,
call on the
my
matter.
provincial has not yet been rejected, Lordship. Lordship, may kindly peruse, Lordship, the impugn resolution, Lordship. And I have also annexed one order of this honorable court wherein it is clearly stated that the joint committee not impeached under the act, Lordship.
That's all right.
Taking note of all these things, Lordship.
That's all right. Let him obtain the instruction and
Lordship,
collect it on Monday. We
3
will
days,
consider your
Lordship.
prayer.
3 times, Lordship, but
In fact,
this,
last day also we prayed for Monday only, because we knew in the law that this has information has to come from. Lordship will accommodate one day, because it's Friday.
Mr. Kosik, learned standing counsel for the respondent in elementary education department, submits that he has not received a complete instruction and a price for listing the matter on Monday. Where allowed, interim prayer of the petitioner will be considered on Monday. Both the matter.
Maybe the last chance, because we are suffering, we are 51 years old. Retired,
51.
51 years old.
Retirement age is 60 years.
That's true.
But anyway, on Monday, we'll consider your prayer. Let him obtain instruction.
Lordship, these 2 matters may kindly be kept as part of, Lordship. Your Lordship has all substantially heard these 2 matters, Lordship.
No, is there any provision
Lordship, that
for
other day,
keeping
Lordship.
the matter as parted in motion stage?
Lordship, your Lordship has already heard the matter, Lordship.
Okay.
Yes.
Item 39.
May it please your lordship. In all fairness, my lord, this is a case which actually the petitioner needs to represent to the authorities because his retired benefits were held up. But as it seems, he had approached the special judge court, saying that although there is no departmental proceeding, but these proceedings is pending, these are held up. And the another trial court said long back that no, you have to approach the department. We have not passed any order withholding it. So may I pray for direction that I approach the respondent authorities with the same prayer? I'll find the representation. That would be better, man. I retired on 2006.
This matter
30th
may
of June.
also pertains to this Banstein matter.
My lordships,
This matter may also pertains to Banstein matter.
lordship. I did not indicate that because it can go anywhere.
Okay. Commissioner and secretary from department. It will Banstein matter.
Pension and pensionary benefits, madam. Retired benefits.
The person is serving in police department.
He was serving.
He was, okay. So, it will go to Banstein.
Lordship.
Or
Except may not Friday and Wednesday. It may be listed, may not within this time. But I'm praying I will not be there.
Okay.
Lordship, a picture in. Like to case, ma'am.
Heard Mr. Bonick, learned counsel for the petitioner.
19 article.
Let's just list the matter before appropriate.
On 18th.
Within
18th.
next week.
And might I be pleased to indicate the date 18th, my lord.
Mr. Bunning, it would be inappropriate for this court to fix a date because the
Wait,
registry,
yeah, Mr.
you go and approve
No,
the
no, no.
registry as soon as practicable. Mr. You take it down as soon as practicable.
Grateful.
Preferably within next week.
Record 14.
May I please? My lord, in this case, the petitioners are the, my lord, guardians of the students also who are, my lord, studying in the three numbers of special schools in the state of Assam. They are mainly aggrieved by the, my lord, mismanagement of the schools by the authorities with regard to, my lord, not providing the teaching teaching faculties, my lord, as well as the other requirements, such as, my lord, these are the residential schools, my lord. The students are, my lord, allowed to stay there, and the service provided by the management, my lord, is very poor. And this is because, my lord, the teachers are lacking. Number of teachers are very few. There is no principal, vice principal, and the other teachers are also not there. As per the RCI norms, my lord, against 10 students, there should be one teacher.
So first you tell me who are you?
We are the guardians of the disabled students. Our students, children are studying there. So at this stage, I shall pray for notice, my lord. In this case, they have to file the reply.
Your Lordship, actually we filed a review petition against the order stated managed two of this petition. The review is registered as review number 15770 of 2025. And after this review petition is listed, this matter will be taken along with the other reviews.
What is the number?
Review number 15770 of 2025.
Review.
Yes,
This is filing number.
Filing
It's not
number.
registered yet.
it's already registered. This is the register.
No, that has not yet been registered.
It's not registered. Filing number.
Filing number, yes. Once it's registered, this matter may be
No,
taken
first I'll
along.
let the
Let it come separate, but notice may be issued in this case.
Heard Mr. Purkesto, learned counsel for the petitioner, and miss your name please.
Yeah,
Learned counsel appearing for
for respondent number 1 and 2.
respondent number 1 and 2, and Ms. Spoken for respondent number 4. And Ms. Borua for 3. 3. This petition under Article 226 of the Constitution of India, the petitioners have pride for issuing direction to the state respondents to fill up the sanctioned vacant post of principal, vice principal, superintendent, TGT, UGT, instructors, etc. of 3 numbers of residential special school. That is BDS Goft Higher Secondary School for Hearing Impaired, Kailipara, Guwahati, Jorhat School for Hearing Impaired, and Jorhat Blind Institution. In view of the order dated 15/7/2025, passed by this court in WPC number 4850 of 2022. And also issue direction to the state respondent to follow the mandate of the National Education Policy 2020. Where is the petition? The documents, lesson record. Let notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their standing counsel. But extra requisite copy of the petition be furnished to them during the course of the day. Place the matter after 4 weeks. In the meantime, the respondent the respondents shall file their affidavit in opposition. List after 4 weeks.
On observation, my lord, pendency shall not be barred for considering the grievance of the petitioners.
Pardon?
Pendency shall not be barred for the respondents to consider the grievance of the petitioners.
No, whether you have filed any representation to that effect.
Yes.
Page number?
Representation, my lord. At page number 54.
Page number 50? 54. Next, sir. Purkeshta Learned Counsel for the petitioner submits that the petitioners have also filed on representation addressing the Chief Minister, Chief Secretary, Secretary Social Justice and Empowerment, Gupta Assam, Disabilities Commissioner, Gupta Assam, and Director of Social Justice and Empowerment, Gupta Assam. And he further submits that the said representation filed by the petitioners have failed to evoke any response. And he further submits that an observation may be made to the effect that pendency of this writ petition would not be a bar for the respondent authorities to dispose of the representation dated 10/11/2025 filed by the petitioners. Accordingly, it is provided that pendency of this writ petition would not be a bar for the respondent authorities to dispose of the representation filed by the petitioners on 10/11/2025. This is the matter after 4 weeks.
Highly obliged.
41.
Where's your watch?
Why?
And then we are starting on the BTC required in this.
Oh,
If we ask. Let's standing up for BTC.
There are other councils also. My friend himself is a standing council for BTC.
the letter come after some time.
Well, in that case, Lordship may have to take it up at 2 because my another matter is been called.
Okay,
I'll be going there
okay, at 2 p.m.
and hearing that will take time later. At 2.
I do 42.
That's it. Volume.
May I please your lordship?
Yes.
Lordship, may please come to page 56. Page 56 of the writ petition.
Yes.
Lordship has passed this order on 5/12/25. Lordship.
Yes.
Lordship, after hearing all the parties, Lordship has disposed of this matter, Lordship. Lordship, may please come to para 5. At page 59. After considering everything, Lordship has passed this order at page 59, para 5.
Yes.
Accordingly, taking note of the submission of the learned counsel for both the parties and also taking note of the relevant rules and also the representation dated 19/11/25 and as agreed upon, this court is inclined to dispose of this petition by directing the respondent number 6 to dispose of the representation dated 19/11/25 filed by the Students' Union, BRM College, for allowing the students to appear in final semester test, passing a reasoned order, keeping in mind the requirement of Rule 12 and also the first proviso to the said rule of 2020. So accordingly, Lordship has disposed of the matter. So next page, Lordship, page 61. On 6/12, the principal has disposed of the representation. Passed this order, Lordship. He considered everything, Lordship. At page 62, Lordship.
Yes.
Now, it is apparent from the closet and details of the writ petitioner that all of them have not attended the minimum 17% class held in the subject concern, and also moot court room exercise, tutorial and practical training conducted by subject taken together. Furthermore, none of the writ petitioners attended 70% of the classes in all the subjects taken together, and as such, they not come under the first proviso of the Rule 12, and hence consideration exceptional reason does not arise. So he has disposed of the representation law. Then lordship, the lordship knows, lordship, before that, in the earlier writ petition also there, the controller of the examination of Guwahati University, he is writing to the principal, they allow someone to do this, do that, at page 63, lordship. Let us read the page 63, lordship. See, after my disposal, I have sent it to the higher education, to the secretary, and I have informed him that the faculty submitted attendance report before form fill up that the eligible candidates are allowed to appear in the examination on the basis of those reports. Examination has already started and it is going on smoothly. So I have informed that also to the secretary, lordship. And I have given a copy to the director higher education, lordship, down below, lordship, at page 63. Now lordship knows one after another, from the controller Guwahati University, there are letters, lordship. Now lordship, page 66, lordship, you can see. The students have filed application, and in the handwritten part, lordship, you can see. With the percentage of 50% be allowed. They may be allowed for one time. And then lordship, these all these 1, 2, 3, 4, 5, 6 is the petitioner number 1, petitioner number 2, petitioner number 3, petitioner number 4, and petitioner number 5 in the writ petition laws. The lordship has already disposed of lordship after hearing. Now he started writing all this. Now lordship, may please come to page 69. It is the second letter, lordship. Again, the same handwritten, lordship. All these are petitioners, lordship. The number 1 is petitioner number 5, number 2 is petitioner number 7, number 3 is petitioner number 4, number 4 is petitioner number 3, number 5 is petitioner number 6, number 6 is petitioner number 8, number 7 is petitioner number 2, number 8 is petitioner number 1. It is, lordship can take note of the date, lordship, down below, handwritten part, down below. The date is 9/12. Till then he is writing all this letter, lordship, I am getting.
No, examination perhaps already started.
Already, lordship. That is what I have written, lordship. In my letter, I specifically mentioned that, lordship, at page 63. I have specifically mentioned that, page 63, lordship, take note. Page 63. After I have disposed of, on 6/12, I have written to the secretary, where I have specifically mentioned the faculty submitted attendance report before form fill-up, and the eligible candidates are allowed to appear in the examination on the basis of those report. Examination has already started and it is going on smoothly. I have written specifically, lordship, and in giving a copy. Now, lordship, may please come to page 70. The same controller, lordship, after I have disposed of my appeal, I have going by lordship's order, I have sent, then I inform the controller that one after another, on 9th also you are writing letter. This is not fair enough, and then you see what is the position. Then the controller has written on 9/12, on the 9/12 itself, lordship, at page 71.
Page 70.
Page
70.
Page 70, lordship. Page 70. Just now I have shown the name, lordship, that application, lordship. Now the controller has said on 9/12. On the same day, Lordship, when he has written the letter, allowed them. Handwritten, Lordship, at page 69. On 9/12, when I informed him on receipt of his letter that the already examination started, you know, you are the controller of examination and you are writing all this and I have informed. Then he said, Lordship, in this letter, it is now decided that the students should not be allowed to appear in the final exam as they do not have required attendance percentage. Lordship, get it. In the second paragraph, last line. It is now decided that the students should not be allowed to appear in the final exam as they do not have the required attendance percentage. Lordship, get it. Now page 71.
So you have been placed under suspension.
Lordship.
You have been placed under suspension.
Yes. Yes, now Lordship, after doing all this, I've been placed under suspension, Lordship.
Applying with the court. Same day.
And Lordship, this honorable minister has visited the college to allow them, all the students. And he said that you allow 2 of these boys. I said, it is not me, it is the controller. Because in the rule, Lordship, there is 2 parts. One is the university, one is the principal. I said, I have not allowed. It is the controller has allowed, not me. I will not allow. So controller has also withdrawn in the meantime, Lordship, on 9. Both the letter, what he has written, he has withdrawn. He said, no, don't give them.
Page 70, 71.
After looking at Lordship's order, and the Lordship, he has written that, Lordship, at page 71, Lordship, take note. Page 71, for a moment. The above is withdrawn as per the suggestion and the impute of the principal of BRM Law College. At my suggestion and the impute, he has withdrawn, Lordship. Hold on there. I have informed him everything. Now, Lordship, while suspending me, no mention about the High Court order, nothing. And Lordship, who has suspended me? Lordship will see. It is the Director of Higher Education. Lordship, at page 73. He is not my appointing authority. Lordship, please come to Annexure 1 at page 28.
Yes.
Page 28, Lordship, on being recommended by Assam Public Service Commission and so and the subject is police verification, the governor of Assam is pleased to appoint so as the principal of the in the higher education demands a scale of so commissioner and secretary to the government of Assam higher education is my appointing authority. Now, this director of higher education has suspended me. And Lordship, what they have written, Lordship, at the top of the page 73, Lordship, may please take note. Because I know my learned friend will refer to that. Let me, he is very fair on that. Lordship, before that, Lordship, under what, Lordship, I have been suspended? Lordship, please read at page 73. Now, therefore, at page paragraph 3, at page 73, Lordship, get it. Now, therefore, in view of the above circumstances, pending trial of the departmental proceeding in exercise of the power conferred under Rule 6(1)(a) of the Assam Service and Discipline Appeal Rules 1964, so and so is hereby placed under suspension with immediate effect until further order. During his suspension period, this is so and so the power until the further order. Now, Lordship, may please come to this Assam Service Discipline and Appeal Rules 1964. Lordship, before Lordship will open the book, Lordship, at page 73, Lordship will have to take note of one thing, because that I will argue, because so that at page 73, Lordship.
Yes.
Down below, copy was sent for information and all, Lordship. My appointing authority was not informed. Commission and secretary has not been informed. No information, no permission, nothing.
No, Mr. Sharma, nowadays this commissioner and secretary post is not there perhaps. Mr. Das?
Yes, yes, madam.
Is there?
Only secretary.
Secretary, commissioner, all is there. Secretary is there.
Earlier, madam, this post, commissioner, secretary, has been renamed as secretary. Now
Secretary.
secretary is only one person.
Secretary. Rename.
Secretary confirmed.
Hmm? If the secretary has been renamed lordship, I don't know. My it is lordship, the power conferred under 6(1)(a) of the Assam Service Discipline and Appeal Rule. Lordship get. Lordship suspension, the appointing authority or any authority to which the subordinate or the other authority empowered by the governor in behalf of the place a government servant under suspension, where a disciplinary proceeding against him is contemplated or is pending. Then proviso lordship, provided that where the order of suspension is made by an authority lower than the appointing authority, such authority shall forthwith report to the appointing authority the circumstances in which the order was made.
Yes.
So, lordship now, in my year, lordship, the lordship may please come to 2B of that act, the rule, lordship, 1964 rule. 2B.
Yes.
Appointing authority in relation to a government servant at any particular time, lordship at any particular time, means the authority empowered to appoint him to the post which he is holding at that time, lordship.
You are referring to?
2B, Rule 2B, interpretation lordship,
Okay.
Rule 2. Appointing authority is defined clause lordship. Rule 2B, appointing authority in relation to a government servant to any party at any particular time means the authority empowered to appoint him to the post which he is holding at that time. So it was defined clause lordship. So the proviso
Okay,
is then
okay. Mr. Das,
no.
you have been,
Yes, lordship.
what more to submit?
No, lordship, one thing only, lordship, because my learned friend will store that, lordship. In the top of the page 73, whereas as the notification file number so-and-so, on 29/5/25, the Director of Higher Education Assam is appointing authority is entrusted with the equal power of appointing authority in clause 31. That lordship that I have given the lordship, that rule is there in the file, I think, lordship. Given copy of the rule is there or not? Citation, assignment, I didn't know. The top of the file.
No, it has not been placed on record.
No, I have given a copy. Lordship, this is published, the notification was published on 28th of May 2025. Lordship, get it in the top of the page. Now, Lordship, what is this? In exercise of the power conferred under proviso to Article 309 of the Constitution of India, the Governor of Assam is pleased to make the following rule to regulate the recruitment and the condition of service of person appointed by the Government College of Assam, namely. So it is to regulate the recruitment and the condition of service. Then in the 2(1)(2), they shall came into force on the date of their publication in the official gazette. Then 2(a), appointing authority means the Director of Higher Education Assam. Here, Lordship, now, as per this rule, it is the appointing authority is Director of Higher Education Assam. Now, Lordship may please come to (31). Because they have referred that in the last page, Lordship, 31. Lordship. The director shall exercise all other power of the appointing authority as per government notification order issued from time to time. That is there in 31. They have given the 31. This order is, and they have referred to this 31. But they have not referred to 19, Lordship. Now, please, Lordship, come to 19. Rule 19 of this rule.
Yes.
All employees of the Assam Government College shall be governed under the provisions of the Assam Service Discipline and Appeal Rule 1964 and Assam Civil Service Contract 1965 and guideline made thereunder. For appointment, Lordship, for recruitment, the procedure is here. For all other purpose, it is the discipline and the appeal. The 19 is very clear that all employees of Assam Government College shall be governed under the provisions of Assam Service and Discipline Appeal Rule 1964. It is specific. So under the 64, DSC is not my appointing authority. When I was appointed, no. Now this is a prospective rule, Lordship. This has no retrospective here. This is a prospective rule. It is in the first page itself, it says it came into force from the day of publication.
Yes.
No prospectivity. And they have exercising the power under this rule. 61A. There is no doubt about it. So, Lordship, this is a non-est order in the eye of law, Lordship. There is no, Lordship, the power is not there with him.
He took 2420.
Lordship, may please come to page 2008, 3 SCC 321, para 24. 22. Page 329. May I read, Lordship?
Yes.
It is one thing to say that the court, while exercising jurisdiction, would be entitled to exercise such incidental power for determination of the principal issue, but it is another thing to say that the statutory authority in such matter would be held to have power which is beyond the scope and purport of the principal provision. Now, Lordship, please come to para 24. Each word employed in a statute must be colored from the purport and the object for which it is used. The principle of purposive interpretation, therefore, should be taken recourse to. Now, Lordship, straight come to para 28. Lordship will get the answer at page 330. Just below the placetum D, Lordship.
A power. A delegation. A delegate must exercise.
Lordship, get it?
Yes.
Lordship, once he fixed a direct nexus, the revision scale cannot be accepted. Once he fixed cut-off date for the purpose of giving effect to so-and-so and the areas and so-and-so and the further jurisdiction in respect of the so-and-so chapter 4, but is controlled by the other provisions of the statute and primarily act govern the field. A delegatee, now Lordship, the answer. A delegatee must exercise this power within the four corners of the statute. The power of the sub-delegate is more restricted. A delegate cannot act in violation of a statute. A sub-delegate cannot exercise any power which is not meant to be conferred upon him by reason of statutory provision. It must be conformed not only to the provisions of the regulation and the act, but also the other parliamentary act. He's a sub-delegate here, Lordship, not even a delegate. The governor power is there with the commission and secretary. He has appointed me, and if my time, Lordship, during my appointment, it is 2017, all interview was done by the APSC. And I'm the topper. APSC has done the APSC. Now, under this rule, Lordship, there is a selection of principal committee, Lordship. To select the principal, there is a committee they have constituted. I am not under that, Lordship. I have not come through that. Any other? So that is my humble submission, Lordship, and my clear case is that he has no power.
So Sharma, you see, now this rule is holding the field. So if any action they have to take under this rule.
No, 64, Lordship. That is why I have read the 19, Lordship. He cannot. He has taken the action under 64 Act, Lordship. In this suspension order, even he mentioned, Lordship. Lordship, see, invoking power under what? Lordship, may please come to 73. Now, therefore, in view of the above pending royalty departmental proceeding and in excess of power conferred under Rule 6(1)(a) of the Assam Service and Discipline Rule.
If it is applicable, it will
If this rule is applicable, Lordship, then this Rule 19 is also applicable.
by virtue of Rule 19,
By virtue of Rule 19, Lordship, you have to decide.
for discipline, my appointing authority is not engaged.
Then he is not there, Lordship, 1964.
No, you come to the proviso of that rule,
Yes,
6,
yes.
sub-rule 1.
Provided that when the order of suspension is made by an authority lower than the appointing authority, lower than the appointing authority, such authority shall forthwith report to the appointing authority the circumstances in which the order was made. Who is that, Lordship?
He has to be empowered to suspend.
He has to be empowered. It's because my appointing authority, empowered word is there at the top, Lordship, in the 6, suspension. An appointing
No,
authority or any
you
authority
see,
which.
Mr. Sharma, you see, having passed this order, the Director Higher Education has communicated the same to the Secretary.
Yes, communicated.
Yes.
Informed before passing, Lordship. Yesterday there is an order, Lordship, to produce that, Lordship. Because Lordship's court was not there yesterday, this bench was not there. So as thus Learned Council Higher Education is directed to obtain instruction as to whether the Director of Higher Education Guwahati Assam has been conferred the power of appointing authority in terms of Rule 1964. That is very specific, Lordship. This court has given an order. Let him show that. Under that rule, Lordship, it is specific. This court has given a direction to him that bring that the Learned Council Higher Education is directed to obtain instruction as to whether the Director of Higher Education Guwahati Assam has been conferred the power of appointing authority in terms of Rule 1964, irrespective of the power conferred under the Government Service Rule 2025.
This does not give you omnibus power to speak.
Because this has not given an omnibus power, Lordship. These Lordship, because Lordship, first, that is why I have shown that they shall come into force on the date of their publication in the official gazette. So this is prospective, Lordship. My appointing authority is my appointing authority, Lordship. Now, by this, he cannot change it.
No,
Then you have to give a fresh appointment order.
no.
For the discipline and appeal rule, Lordship, Lordship, this rule has power, Lordship said. Then this 19 is also effective. If the 19 is there, then you have to go by this 64.
Yes.
If the 64 is there, then this 6 is very clear. How a person to be suspended, he has to be empowered. Where is that empowerment? Lordship, please read the 6 slowly. The appointing authority or any authority to which he is subordinate. Lordship will take note of that. That is why I am reading at the cost of repetition. The appointing authority or any authority to which he is subordinate, any other authority, empowered by the governor on that behalf.
Specifically empowered.
Because now he has been empowered for this act, Lordship.
Yes, the power on the.
Because this rule has referred to that any discipline and appeal, yeah, everything is under that. And that act is very specific. That he has to be empowered.
Those cannot be override. That means
He cannot override.
delegate cannot act on the scope of that one.
Yes, Mr.
And what is Lordship, what is the order? That the Lordship passed an order. I have disposed of my appeal as per the Lordship direction. Now, why is the suspension that you are allowing two boys who are not below 50% and all that? It is the university, controller of university Lordship. Now he has withdrawn on 9. Why I have to be suspended?
Everything will.
I am not there. On 9, even university has withdrawn. When I have disposed of the representation as per Lordship direction. Lordship has passed the order on 5th. My disposal on 6th. Even thereafter, the university is recommending, give them, allow them. He is a controller. Now in this, 2 person can allow university and the
Dean of University.
dean of principal. It is good, isn't it?
Okay, Mr. Das, what is the instruction?
No, but that instruction is not to bring. This is only to confirm, my lord, whether the director of higher education Assam has been conferred the power pending authority in terms of special irrespective. There is no need, my lord. That's why there is no specific.
Need as per?
Your point, my lord, kindly have this notification, my lord, the rules. Assam Government College Service Rules 55. It has been published on 28th of May 2055. Before the suspension of the petitioner. Now, 2A says appointing authority means the director of higher education Assam. Then 2G, my lord, is rule applicable to government colleges means Pokrajhar colleges, Vishnuram Medi government law college. There is the college of the petitioner. Then, my lord, my senior sir has already referred to rule 19, my lord. Disciplinary appeal rules and 31. I will not read again. Now, the petitioner has been suspended under Rule 1964 Assam Service Discipline and Appeal Rules. Kindly have Rule 2B, the appointing authority. The appointing authority mentioned here in this 2025 rule and the appointing authority mentioned in this 1964 rule is, my lord, there is no contravention, my lord. Kindly have Rule 2B, my lord, appointing authority. Appointing authority in relation to a government service at any particular time. This at any particular time, my lord, this particular time is the present time. Any particular time means the authority empowered to appoint him. Now, at this particular time, my lord, this present time, director is the authority empowered to appoint him to the post which he is holding at that time, my lord. This that time and the particular time is the present time, my lord. It says, my lord, the government surveyor at any particular time means the authority empowered to appoint him to the post which he is holding at that time. So now, my lord, he is holding the post of principal, and at this time, my lord, by virtue of this 2025 rules, appointing authority means the director, my lord. And the director has rightly passed the suspension order. Had that been, my lord, the appointing authority means that the earlier appointing authority, this sentence would have been different, my lord. It would have been the in relation, appointing authority in relation to a government servant at any particular time means the authority. It would have been the authority who had appointed him. Had this appointing authority means that earlier appointing authority. And the last sentence would have been to appoint him to the post which he is holding. It would have been he was holding. Since it says he is holding at that time, this present time, and at present time, the appointing authority is the Director of Higher Education by virtue of this 2025 rules. So there is no different conflict between the appointing authority mentioned in 2025 rules and the 1964 rules. And my lord, rule 6, suspension. Even for the sake of argument, my lord, even for the sake of argument, I say that director is not empowered. But this rule says suspension. The appointing authority or any authority to which it is subordinate. Then this sentence is different, my lord. Or any other authority empowered by the governor. Empowered by the government is required for any other authority who is not subordinate to the appointing authority. Not this empowerment is not necessary for the authority who is subordinate to the appointing authority. My lord. That's why it says that the appointing authority or any subordinate authority to which it is subordinate to any authority to which it is subordinate may place a government servant under suspension if the authority suspending the incumbent is any other authority which is not the subordinate or the appointing authority. Then the governor has to empower him for suspension. It says this manner. Otherwise, kindly have the next page provided in rule 6 only. It says that provided that where the order of suspension is made by an authority lower than the appointing authority, such authorities are forthwith report the appointing authority to the circumstances in which the order was made. That has been informed, duly informed. Otherwise, here also, this sentence would have been, dear my lord, if the empowerment of the government is required, then it would have been, my lord, provided that where the order of suspension.
So, Mr. Das, your contention is that
Yes, ma'am.
for the appointing authority or any other authority to which it is subordinate, this authorization is not required. That is your argument.
No, my argument is, my lord, if the suspending authority is the appointing authority or the authority subordinate to it, then
And this authorization,
by the government is not required. It is required only for the authority which is not subordinate to or not the appointing authority. Say,
no,
my lord,
Mr.
give
Das,
an
you
example,
see
my lord.
here, the word or is used.
Or,
Hmm.
but this, my lord, kindly see. Then, my lord, is any other authority would not have been mentioned, because other than appointing authority, everybody would have required the empowerment by the governor. So any other authority, there is no necessary of any other authority. Any other authority is mentioned here because empowerment by the governor is required for any other authority who is not the subordinate to appointing authority or the appointing authority. So in my humble submission, my lord, this 2B appointing authority.
So,
mentioned-
your submission is that the appointing authority, present appointing authority is not authorized by the governor, not empowered by the governor,
not empowered by the government, and that is not required also.
not required.
Yes.
Okay.
Because by virtue of 2025 rules, my
Yes.
lord,
So authorization is not required.
no, by virtue of this 2025 rules, the appointing authority is, my lord, director, and he has been and these rules came into force prior to the suspension of the petitioner, and the rule 2B of 1964 discipline and appeal rules is not in conflict with the appointing authority mentioned in 2A of the 2025 rules. Because kindly similar to 2B, I will be reading again 2B of the 1964 rules. Appointing authority in relation to a government servant at any particular time. This at any particular time is not the variant. It's not fixed that earlier time. Appointing authority, this means at any particular time is we have to consider it present time. Madam. Appointing authority in relation to government servant at any particular time means the authority empowered to appoint him to the post which he is holding at that time. So at present, the director is empowered to appoint him as appoint him in his post. Principal. So the director rightly passed his suspension order. He is the proper authority to pass the suspension order. Because this would have been different. The meaning, if we consider that appointing authority, prior appointing authority, now if the appointing authority changes, even if then we have to consider the prior appointing authority, then this sentence would have been different, my lord. Appointing authority in relation to a government servant at any particular time means the authority, this would have been different, means the authority appointed him. It would be by this sentence. Authority appointed him to the post which he was holding. But this sentence is different. Madam. He is holding means he is holding right what he is holding and the time. At his time, who is the appointing authority? And by virtue of this 2025 rules, our director is the appointing authority. And there is no conflict between two of 1964 rules and 2025 2A of 2025 rules.
Okay.
My lord, and my learned senior sir has said that the petitioner was suspended because he is compliant with the order of this honorable court. That is not true, my lord. Kindly have page 72. I'll place the inquiry report also. First, my lord, I'll page 72, my lord. Thank you, order. In pursuance of the complaints received from the students of college and the subsequent visit of the Honorable Minister of Education, Government of Assam to the college of 8/12/2025 to assess the situation, the Honorable Minister directed that a team of officers from the Directorate of Higher Education Assam be deputed to inquire into the matter and furnish an inquiry report immediately for the greater interest of the student community of BRM College. Whereas on 19/12/2025, the inquiry team submitted its report. After careful examination of the inquiry report and all relevant documents, it has been found that the principal of BRM Government Law College allowed students to appear in the LLB semester examination despite their attendance being less than 70%, and in some cases where attendance was 50% or below, in gross violation of Rule 12 of the Bar Council of India. So that is the reason, madam. The principal has allowed students to participate in the examination who has attendance less than 70% or in some cases less than 50%. It is not because that he has allowed two students, dismiss two students while disposing of a representation pursuant to the order of this honorable court, madam. Now, madam, kindly this rule 12 is quoted here. I'll not read the last paragraph. Whereas, being the head of the only government law college in the state of Assam, the principal was expected to ensure strict compliance with all regulatory provisions. The inquiry has established that the irregularities occurred under his administrative authority for which it is fully responsible. Accordingly, there is a need to initiate departmental proceeding on this matter. Next, it talks about this notification matter, the rules. Then, Malad, the second para, the suspension is necessary to ensure an impartial and unhindered departmental inquiry, as the presence of the principal in office may influence witnesses or tamper with records relevant to the case. Given the seriousness of the violation and administrative responsibility vested in the principal, suspension is essential to maintain the integrity of the inquiry process. And now therefore,
So, Mr.
he
Das,
has a preventive suspension because Malad, he is holding the post
Preventive suspension.
and Malad, as per my instruction, he has also written a letter for leave, and now Malad, he has locked the locker and along with all the attendance registered Malad, and he has gone out of the college with the keys Malad. So it is locked, the attendance. Now the fair is that if he is allowed to join his office, Malad, then to save his or in defense, he can manipulate the register Malad. Because the allegation is Malad, that he has allowed certain students who doesn't have attendance up to 70% or 70%. And inquiry report, Malad, I'll place.
Let's say I'll get a copy, let's go. হাইকোর্টের কাছে রেফার করেছে না এনকোয়ারি রিপোর্টের সব
May I read Malad?
no, not necessary.
দেখুন না হাইকোর্টের রিপোর্টে নাই হাইকোর্টের অর্ডারের কথাই নাই এই জন্য এই জন্য দেখছি
Kindly see page 3 and all, Malad, there are complaints by students.
এগুলো তো
regarding,
রিপিটিশন হতে গেছে
attendance, and the discrepancy and permission, Malad.
এগুলো তো রিপিটিশন হতে
No, whether this report observation at point number 1, it is a hearsay or there is any record that 2 students whose attendance were below
That
50%
record
were
is
allowed
not
to.
in my instruction, that record is the Malad, attendance book. The attendance book has been locked by the principal, Malad.
Then on what basis this observation, the inquiry committee arrived at such a finding?
They went to the college, Malad, the inquiry committee. Then when they saw this inquiry report was given, thereafter, Malad, he locked all these attendance register and all. Malad.
No, whether the committee has checked the attendance register or not.
No, could not seize, Malad. If Malad allows, Malad.
No, I am not asking you about seizing.
Yes.
I am asking about whether they have seen the attendance register or not.
As per my instruction, Malad, they have seen, Malad. And after.
Then why the names of the students are not there in the report?
How many? Nothing. Lock করা বলি আমার কই লক করা বলি আমার কই
Well, particular names are not there, Malad, but the authority has found that, Malad, he has made allowed.
No, that would have been more transparent if this inquiry report.
মই connected এতিয়া মই connected এইখনে মোক সহায় কৰিব This will help us.
Better, Mr. Das, you obtain instruction. We will resume hearing at 2 o'clock. As to who are the two students whose attendance were below 50% and they were allowed to appear in the
Yes.
examination.
And who is continuing in the examination? Lordship, only one thing, Lordship, please see, last page of this report. The same person who are the writ petitioner has signed. And when on 8/12, after my disposal, after Lordship disposal the writ petition, the same person has given this complaint. And on their complaint, Lordship, the minister visited. And this person, when they visited my office, I was there in the office. I have opened everything. All the professors were called for in the room. They have said everything. They have seen the attendance register and when they have not get anything, so they have not written anything. And these are the person, Lordship, they are the writ petitioner, Lordship, before your Lordship. 8/12, after the disposal of the writ petition, not a whisper, Lordship, that there is an order of this Guwahati High Court. Not a whisper, Lordship. Unfortunate, my Lord. Following the High Court order, if somebody will suffer, is something unheard of, Lordship. And I'm grateful, Lordship, my learned friend has placed this. Because I do not have a copy of this. When this person visited, I was there because examination was going on. And there is not a single word, Lordship, that it was lock and key. Not a whisper, Lordship. Not mentioned, Lordship, in the inquiry report. I'm there. They call all the professors because it's not my duty to give the percentage, Lordship, it will be professor. They dictated the professor, give the percentage because minister want that. But all my professor has refused. I'm really proud of them, Lordship, they have refused. Even after the minister visited, Lordship. They refused. Because they said that there is a High Court order. And what, Lordship, what he's saying? Lordship, please come to page 52. It is black and white, Lordship, because this is a para-wise comment to their advocate, Lordship, from the principal, page 52.
That reflecting the order.
And this is reflect in Lordship's order. Para 4 in the para 4 of Lordship order. This page 52, Annexure 7, 512. My principal has written all these. Who has how much of percentage? And this is reflected Lordship's order, para 4, Lordship, please see. Page 58. Lordship, ditto Lordship is quoted. Page 58, para 4.
Okay, we'll resume at 2 o'clock. Let him obtain
Lordship,
instruction.
but I'm grateful, Lordship, this inquiry report is here, Lordship, because I do not have a copy of this.
Item number 42 to continue. Sometime, after.
Only one thing, Lordship, I want to show. Lordship, my learned friend said that is all lock and key at that time, the inquiry cannot proceed. Lordship, in the inquiry report, in the second paragraph, in compliance with the said direction of so-and-so, and conducted an inquiry into the matter. During the visit, the principal, faculty members, and the concerned students were interacted with, and the relevant document were examined. Now, Lordship, here in this case, there is an application to the minister. In the last page, Lordship, the Honorable Education Minister, it was sent on 8/12/25. second last. Lordship get it. Lordship, in the context of the application, Lordship, nowhere it is mentioned that they have moved this High Court. High Court has disposed of their petition. Nothing. It all depends on fraud, Lordship. Lordship, see the next page.
10 out of them were.
Out of the signatories, 10 out of them is writ petitioner before the Lordship. One by one, I can say, it is the number one.
Mr. Sharma, not necessary.
Yes. It is something unbelievable, Lordship. High Court's order has been here, and the Lordship's question is the pertinent question. That after the Lordship's order, who has appeared before the year who is below 70%? That is the pertinent question, Lordship. Nothing is mentioned. Not a single name, not a single roll number.
And this is an inquiry report.
And Lordship has seen from 72 suspension order started up to 71. Even the Guwahati University withdrawn after the High Court order. The Guwahati University has given 2-3 letters, allowed them. They have also withdrawn. Saying that the principal of the government law college has given us this year and we came to know about it. Now we have withdrawn. And then I have been suspended.
Okay, let him produce the record.
Lordship, let them put it.
Yesterday also the authority, some officers went to the college, but it was found that all the visitors were locked by the petitioner.
No, that's all right, but while the inquiry was conducted, no, Mr. Das, you see, when this inquiry was conducted, all the stakeholders were present there. So, but interestingly, the name of the two students who were allowed to appear is not there.
Only things were not there, my lord. That's why, my lord, I am praying, my lord, let this matter will come up on Monday. In the meantime, my lord, director or planned us some, sorry, my lord, director.
Now they will manipulate.
No.
To manipulate.
Visit, do seize the attendance sheet and produce people the full, my lord. Everything.
No. First,
My
you.
lord, appoint some advocate commissioner also, my lord.
No.
To seize the document.
You not required Lordship
Otherwise, this fact will not
Inquiry is
come-
complete. They have given a report.
No. You just tell me the name of the two students who were allowed.
That's what I am saying. It says that
If
they have examined the.
But why their names are not there?
It is too much, Lordship. To suspend a person, Lordship, this type of behavior, Lordship, something unfortunate, Lordship.
Director authority or appoint an advocate commissioner to seize this document.
No.
Otherwise,
Yeah, suspension matter, Lordship,
my lord,
all this.
this attendance registered has been blocked by the petitioner. And yesterday also the authority went there, they could not take out
Why?
or seize.
No.
To do what?
Mr. Das, you say, after going through the record, this finding number 1 is recorded. Right? Where is that record? What are the names of the two students who were allowed?
Nobody, Lordship. Even the university has withdrawn.
They have written down the names, madam. That was the mistake committed by the officials who went.
No,
But
in-
that
in-
doesn't mean that.
In that case, we will interfere with the order. In that case, we will interfere with the order.
No, what means the submission is, the humble submission is that,
Eh,
thus not mentioning the name will not, initiate that suspension order or the inquiry, that's what, to bring this all facts, my lord, kindly,
So before 3 o'clock, you produce the name of the two students.
or my lord, kindly allow the authority to went there and see the.
No, that question will arise later on, not now.
Name,
No. You have inquired, you have gone there, you have interacted with them. Who are those persons?
Only not.
The last line is very clear, Lordship. After hearing all parties, students, teacher, principal, and verifying relevant attendance record and all documents, the following observation were made. This is the report. And now he said that the something was not.
Okay.
I think about 16 and 17 for one.
So these are similar matters where lordships have already passed orders, madam. These are all the secondary department. Page 3,
No, 314.
Page number 314 is the similar order, madam. Lordship had passed, madam. Those grade 4 employees working in various education departments, madam. Being granted fixed pay, madam. Page 314, your lordship's order starts, madam.
So you want similar order to
Similar.
be passed. Okay. Any objection from the secondary education? Why?
Because your lordship.
They will file individual representation and you verify it.
Yes.
70 is also similar.
Okay.
Similar.
I'm appearing for 1 and 3.
Okay.
And your lordship in Junalida's repetition 7107, that is 2025, appearing for 1, 2, and 3. I'm declare this.
I'd like to.
I think I do 41.
May it please, Your Lordship. Well, the issue relates to appointment of teachers in the upper primary and lower primary schools under the BTC. Now, the BTC here, they floated a recruitment notice for filling up of the post of assistant teachers. And along with that, kindly see at page 84, this is the advertisement.
For lower primary, two advertisements.
Two advertisements, one for lower primary, this is assistant teacher, LP schools.
Page 89.
And 89 is the advertisement pertaining to upper primary schools. We all applied and fulfilled all the conditions as required. Along with this, there was a notification attached to requiring that they will have to fulfill certain certain requirements. At page 145, Lordship will see. Annexure 8.
Page number
145.
145.
Annexure 8, page 145. List of testimonials documents. They wanted that these documents should be produced by the petitioners. It is pertaining to NIOS, Lordship may recollect.
Yes, yes.
That is requirement of those Lordship has been hearing such matters. Now, it says in view of the, I'm reading that notification, my lord, 17 June 2025. In view of the judgment of the Honorable Supreme Court of India passed in dated 10/12/24 in review petition number such and such, in the case of so and so and others, applicants who have successfully submitted their online applications with 18 months DLED from NIOS against the advertisement dated 26/12/2023 are hereby asked to attend the second phase of physical document verification in due course of time when notified with the following documents in originals and one photocopy set of all documents for the proof of in-service teacher as on 10/8/2017. They basically wanted that those candidates who have qualified in DLED through NIOS, National School of Institute of Open Schooling, they should produce that they were really in service at that point of time. That was the requirement. And then what are the documents they wanted? List of testimonials documents down below. paper related to proof of in-service as on 10/6/2017. This is the ballot cut-off date they want. Then one is appointment letter and accepted joining report of the applicant. B, minutes of the school managing committee of the school in respect of appointment of the applicant concerned. C, photocopy of the attendant register of the school during the service period of the applicant duly countersigned by the head of the institution. D, certificate issued by the school authority specifying the service of the applicant in the school as on 10/8/2017. E, salary statement stating the pay band, basic pay, DA and other allowances of the applicants for the entire service period. F, UDICE record as a proof that the applicant was in service as on 10/8/2017. Now, Lordship is aware by the time that this was also put to challenge. Learned coordinate banks of this court dismissed certain petitions, writ petitions, challenging this, that this is not legal. That was taken before the appellate court, and the division bench of this court has said that subject to final decision, all those who have who even could not fulfill all, they should be allowed to participate, subject to further decision of this court. That is the interim order, I am told. Now, in my case, what happened? All these petitioners have fulfilled all the conditions minus F. Minus F in the sense, that is the UDICE court. They insist that at the relevant point of time, that is in 16/17, there must be an UDICE code, and there your name must appear as a person working there. But here, their names appear in the UDICE code, but in a later point of time, not during that particular period, 16/17.
But date of joining is.
But date of joining has been shown there in that UDICE code, subsequent UDICE code, which reflects a date prior to 10/8/17. Therefore, kindly see this, page 26. Page 23 starts. This is, my lord, downloaded copy, printout taken from the system, Unified District Information System of Education Plus. This is data capture format. Their data contains academic year 2018-19 at page 23, lots of seen it. Middle part. This is academic year 2018-19. They have shown 23 pages. Here, now kindly come to page 26. Petitioner number 1, his date of joining is 1/10/2016. This is shown 1/1/2016. That is in the middle. Lordship will find it. On 3/3/14, date of joining in service, 1/1/2016, 1/1/2016. The name of the teacher is Ashok Narjari, petitioner number 1. 26 at the top, name of the petitioner. Then all other details has been given. And when was he working in the school? That should initially joined, date of joining in the service, 1/1/2016, 1/1/2016. This is a specific data recorded in the UDICE code of 2018-19. Now, whether that fulfills the requirement. Whether that fulfills the requirement, although UDICE code, which was there in 16/17, there this information is not available. Whether that by itself will be sufficient to hold, notwithstanding this particular information recorded in 2018-19, that he was in service and joined the service initially on 1/1/2016.
Page 38 to the high, page 38, similarly, page 38.
Kindly see page 38 similarly. Lordship may kindly come to. Here, in the similar column, date of joining of this petitioner, Ranjit Doimari. Ranjita Doimari. It shows 21/2010. Hmm?
1/11.
Sorry, 1/8/11. 1/8/11, middle column. Date of joining in service 1/8/11. Similarly, all these petitioners, date of joining has been reflected in the UDICE code subsequent to the year 2016-17. Now, we have gone through the process of verification. Everything found right. Otherwise, of this entire list, -5, also, I mean the F. I will like to submit that even F has been fulfilled. Not that I have failed to comply with F. I would have argued otherwise that those are irrelevant and unnecessarily put. There is no meaning at all. Probably this argument was taken before the learned division bench, and the division bench has said, all right, you now go ahead, but subject to further result, we will decide later on. This is how the position stands. And in my case, it is fulfillment of all other conditions from A to C, A to E. I have given all that. There is no issue at all. Those are sufficient enough to establish that I was in service that time, including the attendance register, then my appointment as a salary statement, managing committee's resolution, everything has been given. No issue there. But UDICE code relates to 18-19. They say it ought to have been 16-17.
But the criteria does not say, criteria does not.
But
criteria not.
does it say that it must be specifically 16-17? Here they only say that UDICE code, your name should appear. UDICE record is there. That shows we are in there in service in the relevant point of time.
But
That is
for that
one.
particular year, you have not possessed the UDICE code.
Yes, in that particular year. 16-17, subsequently it was recorded, all records were done. They entered all these records. Well, it happens, so happens, certain schools, they do not submit in time. UDICE code, they will have to create it themselves. Therefore, it could not go on record
So,
there.
these documents were of which year? This page number 40,
Sorry, Malik.
page number 40,
Page number 40,
general profile.
page number 40. See. All these are
Yes.
25, 26.
No, when
This is-
these documents were obtained.
Yes. Oh, those were obtained from the mechanical paiswetu.
They have given us UDICE record.
UDICE record
Obtain online.
obtained online.
When?
Hmm?
When they ask for this criteria.
When they wanted these records,
Hmm.
then these were taken down from the system and placed before the authority.
Already online is available.
Online is available. This is online available. This was not prepared by us or not by the school. These are maintained by the authority. This is SSA. They
No,
maintain.
these documents were filled up prior to the advertisement.
Yes, prior to the advertisement, those were done, those were maintained, and there they have shown since when the particular person is in school working. Now, in this particular page 40, Lordship asks for Preeti Brahmo.
Hmm.
She was there. She was shown as a 6th 6/1/2017 in the school. Date of joining in the school, 6/1/2017. But this record is of 25/26, page 37. So these informations are already recorded on the basis of the records submitted by the relevant school. This is how it is there. And I may also inform your lordship, it NIOS contested the case. Here NIOS is a party. In the rate appeal, NIOS was also a party. There NIOS submitted an affidavit stating that we have verified at the relevant time. And only then they were taken in the course. That was there. We have verified thoroughly.
Is
And
that
having
the
been-
document part of this record?
No, my lord, this was filed in the appeal. It is not a part here, though they are a party here. Huh? It was filed on 10/12. We have obtained a copy. Here they say, my lord, I will just read out paragraph 5. Then a deponent further is begs to state that the admission of DLED learners has been verified by the concerned school institutions, headmasters, principal, with due monitoring by state nodal officer. The headmasters, principal of the concerned school did the authentication of the teacher record, Annexure 2. So they said they were duly verified, authenticated by the nodal officer, only then.
Now you tell me at what stage the process is pending?
What is the process is pending? We have
Process now.
Yes.
Appointment is going to be issued. They have not finalized, have not published any final merit list.
verification has been done.
Verification is complete. We have gone through that process. They will be able to.
Instruction. Lordship, the submission made by my learned is not correct. Because verification process is on. In fact, this petition is premature, your lordship. How they have come to know that their candidature will not be rejected? And I don't find any informality, the notification date is 17/2025. It is in terms of Honorable Supreme Court's order passed in Bishwanath and Honorable State of Uttarakhand.
No, that's all right.
Lordship, and I'm told Lordship, today the matter appeal has come up, the daily cause list, item number 17, and I'm told no stay order has been granted in this matter. Today the matter is, it's not on of your order, I could not let it go, but it has happened, item number 7, the same parties, your lordship, wherein the repetition has been dismissed by the court of one branch. Let the matter be taken up because I've specific director for director of education.
It would be made clear to the appointees that the appointments would be subject to the আমার পদ্ধতি দেয়া নাই এইটো
No, you see, no, you come to the last,
Page 145, Mike.
yes, last condition. That notice. F.
Lordship.
145F. You guys record as a proof that the applicant was in service on 10/8/2017. Now you tell me whether this page number 41, for example,
Yes.
is not sufficient to show that at the relevant point of time he was in service.
Instruction from the authorities concerned. Let the matter be taken up immediately after the reopening, my lord.
No, in the meantime, if you complete the process.
I had taken before 2 o'clock. When I come to know about this matter, your lordship, yesterday, last night, I've not looked into the repetition. Today, my lawyer was supposed to appear, Mr. B. Mishra, he said I should appear. So I immediately took telephonical instructions from my client, Director of Education, BPC. He said, my lord, this verification process is on. And the appointment order likely to be issued after, this one, my lord, after 20th of January. So lordship, kindly mark my word, they will not issue any appointment order, my lord.
If they are.
Let this matter be taken up the first week of January, immediately after the opening.
No, better you file one short affidavit
Lordship,
indicating whether this page number 41, for example, is not sufficient to show that they were in service at the relevant point of time.
That will be observed in the this one order, this order. I'll file affidavit.
So, my lord, till then at least,
No,
because
my lordship.
Lordship may record it.
Submission, my lord.
Lordship
They
may
are not
record it.
going to do anything.
Lordship may record it,
Yes,
that
but I
it
could
is the
submission.
statement that they are not going to make any appointment prior to 20th of January next,
Yes, that will be.
2026. And if Lordship fix the date before that, then okay. Otherwise, Lordship will say that if it is to be posted
No,
after
it's premature.
20th.
See, my lord, verification process is on.
Verification process, if on, it is in respect of somebody else. In the verification process itself, we were told that, look, this is not there. So your candidacy will be cancelled. Yeah, this is my case.
Fix the matter on coming Wednesday. This Wednesday.
Specific.
I'll take instruction. But it will be difficult, my lord, whether, because they have to verify, because verification process is on, my lord. So they have to tell me on what basis, like, this notification will show, whether this document is not sufficient or not, my lord.
They will have to, instruction will not do, they will have to file an affidavit. Instruction, my learned friend is saying that she has taken it, they are not going to make any appointment before 20th of January, 2026. If that is so, Lordship will before that fix it and give it date. On that day, Lordship will further consider and pass an appropriate order, considering their affidavit. On the condition that, on the statement made by the London Senior Counsel on behalf, that they are not going to make an appointment, Lordship will pass an order.
Okay. Okay, so how many pages are there, like this, page number 41?
This starts from, you want to pass, huh? 23 to 83. From 23 to 83.
83.
83.
In respect of all the,
All the
petitioners? Okay.
All the petitions.
So, madam, you obtain instruction,
I know.
in respect of this, annexer 1.
In some of 43 on, 23 onwards.
Yes.
There is sufficient, my lord.
Okay. So we'll pass the order then.
Fine.
Yes, and next item.
Post dated run, because lordship may record my submission.
Yes, yes.
Fine.
Yes.
Lordship may fix it. Date,
Date will-
7th of January.
Thursday. Or whether you will be able to file it on Thursday.
No. Sorry, 7th.
In the January, month of January.
18 December.
No, I mean, the first week of January it may be taken, no?
First week of, okay.
Yes.
January 1st week, 7th,
Date be given. in lordship.
8 January.
Okay.
8 of অলপ বেশি মেটাৰ ফিক্স হৈছে।
Now, all to some, no.
9/25.
9/25.
7th. Apply.
Your lordship.
Yes.
Lordship, the petitioner herein is aggrieved by non-compliance by the respondent number 4 to a speaking order dated, Lordship, the speaking order dated 6/9/2025, your lordship. Lordship, the petitioner herein had applied for towards the post of assistant professor in the Department of Assamese before the Skilapatha College, your lordship, in the year 2020, your lordship.
Department of?
Department of Assamese, your lordship, for a post of assistant professor.
Hmm.
What had happened, your lordship, prior to the speaking order being passed, a writ petition was filed by the petitioner, wherein it was against a previous speaking order that was passed by the Department of Higher Education, your lordship, where they had failed to take into consideration certain documents which were necessary for qualification to the post of assistant professor, your lordship. Towards that, the Honorable Single Judge had held that in doing so, the Department of Higher Education was not in the right in holding that the document should have been produced of the petitioner and the marks that were awarded, it has to be re-scrutinized. This re-scrutiny was done. And if I may have your lordship's attention to page number 167, your lordship, the typed copy for the same will be in the preceding pages, your lordship. Last page. Your Lordship.
Yes.
Lordship. In the last paragraph, second last paragraph, since awarding of marks for publication in the matter concerning subject experts, this directorate deemed it appropriate to seek re-verification by the selection committee. Accordingly, on 23/2025, the committee was called. Due to absence of all members, verification could not be completed. Thereby, on 18/8/2025, two subject experts were called and deputed to verify the marks in the presence of the undersigned. Smriti Deepika Borua, who is the petitioner, Your Lordship, is entitled to 4 marks for a Scopus Index Journal publications and 1 mark for a ISBN publication. Dr. Brojan Sharma had been wrongly awarded the marks under the ISSN UGC recognized books as per clause 2.3 and clause 2.4 of the OM dated 8/11/2018. As such, the final marks of both the candidates differ that the marks originally awarded by the selection committee. In view of the above facts, circumstances, the undersigned deems it fit to remand the matter back to the college authority to rectify the proposal for appointment of assistant professor in the Department of Assamese, unreserved, advertised on 11/8/2020, and duly consider the marks under the two categories of Scopus publication and ISBN publication. The principal, Silapathar College, shall submit the rectified proposal to the office of the undersigned within the period of 15 days from the date of issue of this order. Lordship, we are aggrieved by the principal not doing the same and not complying with the speaking orders directions, Your Lordship, whereby we should have been given our appointment orders to the post of assistant professor in the college. That has not been done, Your Lordship. That is why we are before Your Lordship in this matter.
No, whether they have again, the selection committee has again adopted any resolution?
Lordship, no. What the direction clearly indicates that the marks that are awarded to the petitioner and the respondent number 6 therein, the respondent number 6 therein was somebody who got awarded more marks than he had deserved because certain documents that were accounted for could not have been done in the right way. Meaning thereby that we lost that position. An appointment order for the respondent number 6 therein was issued, which was wrong. That is held in this, on perusal of this speaking order, it could be ascertained, Your Lordship. Now, this speaking order clearly states that our marks were higher. Higher in the sense that our marks were not counted for the Scopus publications. Therefore, the matter was remanded back to the principal. The principal, in accordance with this speaking order, should have passed a requisite, an appointment order in our favor, Your Lordship. Considering.
Whether the matter is not supposed to be placed again before the selection committee, who will award the marks?
Lordship, the marks have been awarded by the
Selection committee.
Determination of marks is done by the directorate.
With please, Your Lordship. If Lordship is pleased to go through Lordship, when the matter was originally remanded back to a director of higher education, Your Lordship, she was supposed to do a verification of the marks, Your Lordship.
No,
So,
you first
accordingly-
tell me who awards the mark.
The selection committee, Your Lordship.
Selection
And
committee.
they've accordingly they've
Then,
sat and they have
how,
awarded the.
how can the principal award the mark?
The principal, we're not against the
He
principal.
he
awarding
has
the
to
mark.
place the matter before the selection committee.
It is was before the selection committee, Your Lordship.
Yes.
That is what the
Thereafter?
speaking order states. And thereafter, after taking into consideration the various journals, Lordship, our matter was placed before a selection board, and accordingly, they have reduced the marks of the respondent number 6 therein and increased our marks. And by virtue of which we qualify to be the assistant professor of Assamese, Lordship, in Hilapathar College. So the principal is not complying with the same, Your Lordship. That is why before this honorable court. She's supposed to send a new rectification letter to the DHE. She's not doing the same. That is why we also made her name by party, Your Lordship. Maybe some malafide on her part also. Lordship.
Okay.
That is the case.
Yes, Mr. Towelder?
Lordship, we have forwarded the college authority to the
Yes.
scheme order. Now, we have not received any communication from them. So, Lordship, at least this notice may go to the principal of college.
Lordship.
Because they have already made the.
We made no part, Your Lordship. No grievance against the DHE, Your Lordship. They have done their part, Lordship. The principal is not complying. with this.
Better you obtain instruction.
Yes, ma'am.
Why the matter is not forwarded again to the
Yes,
director?
yes, I will do that, Lordship.
The Lordship will fix a short date, Your Lordship, maybe on 19th.
Heard, Mr.
And got to my Lordship.
Learned counsel for the petitioner. And Mr. Govilder, learned standing counsel for the respondent in higher education department.
Seven one eight.
This petition, under Article 226 of the Constitution of India, the petitioner has applied for issuing direction to the respondent number 4 and 5 to forthwith rectify their proposal for appointment to the post of Assistant Professor in the Department of Assamese of Silabhatar College by duly considering the marks of the petitioner and the respondent number 6 in terms of the speaking order dated 6/9/2025 issued by the respondent number 2, and to forward the same to the office of the respondent number 2, and also to direct the respondents to forthwith select and appoint the petitioner to the post of Assistant Professor, Department of Assamese. Mr. Gautam, learned counsel for the petitioner, submits that the petitioner has filed one writ petition being WPC number 4605 of 2023, wherein by the order dated 28/6/2023, the respondent number 2 respondent number 2, wherein the selection of the respondent number 6 to the post of Assistant Professor in the Department of Assamese of Silabhatar College by the selection committee was found to be justified upon verification of credential of the petitioner and the respondent number 6 by the OSD to the respondent number 2. The said writ petition was disposed of by the order dated 7/1/2025 by remanding the matter back to the respondent number 2 with a direction to take steps strictly in accordance with the direction passed by this court in the WPC number 7061 of 2021. And there was also a direction to pass the final order of appointment to the said post. And the respondent number 2, in compliance with the direction of this court, passed the speaking order dated 6/9/2025 and recommended that the petitioner is entitled to 4 marks for her Scoop House Index journal publication and 1 mark for her ISBN publication, whereas the respondent number 6 had been wrongly awarded 2 marks under the category of ISSN/UGC recognized books as per clause 2 Roman 3/Roman 4 of the OM dated 8/11/2018. And in view of the aforesaid recommendation, the matter was remanded to the respondent number 4 and 5 by the respondent number 2 to rectify the proposal for appointment of Assistant Professor in the Department of Assamese by duly considering the marks under the 2 categories, that is Scoop House publication and ISBN publication within a period of 15 days with effect from 6/9/2025. But the respondent number 4 and 5 in most illegal and arbitrary and malified manner is sitting over the matter by not following the directive of the respondent number 2. The submission of Mr. Gautam, learned counsel for the petitioner, next further consideration at this stage. Notice be issued to the respondent, returnable in 4 weeks, Step upon respondent number 4, 5, and 6. You are representing the governing body also?
1, 2, 3.
1 and 2. 1 and 2. Step upon respondent number 3, 4, 5, and 6 be taken by registered post with AD and also by usual process within a week from today. Additionally, Dusty service is also permitted, and after effecting service by Dusty mode, the petitioner shall file an affidavit before this court. In the meantime, Mr. Towbilder, Learned Standing Counsel for the Higher Education Department shall obtain instruction as to why the direction of this court. Why the matter has not been taken to its logical conclusion as per direction of the respondent number 2 within the time frame that is 6/9/2025. List the matter on.
Lordship, in view of the fact that Lordship has been pleased to issue notice returnable in 4 weeks, so Lordship, we are under apprehension that perhaps they may advertise for filling up this vacant post of SMEs, your Lordship. May I pray for till the next returnable date, Lordship, no fresh advertisement for filling up this vacant post of SMEs, your Lordship.
That is only your apprehension. You have not mentioned it in your.
It's there, Lordship, on page number 25, your Lordship.
Where?
I prayed for interim order, Lordship. Page number 25. Since Lordship is giving 4 weeks, your Lordship, that is why it's.
No, we can fix the matter after 2 weeks also, but the question is whether you will able to serve notice.
Lordship, interim order will protect us, your Lordship. It does not harm anyone, your Lordship. Not to fill up, your Lordship. Not to fill up. It is vacant as of today, your Lordship. When under an apprehension, since we have filed this case, Lordship, they may issue a fresh advertisement. We are under an apprehension, Lordship. This does not harm anyone. The post is vacant.
The interim order will affect Lordship.
The post is vacant, your Lordship. I am entitled to that post, your Lordship. It will not harm anyone. It is in my interest, your Lordship. No, and it will not harm the interest of the college, your Lordship. The post is vacant, your Lordship. Clear government, your Lordship. Post is vacant. Post is vacant, your Lordship.
Instruction, Lordship.
Okay, no. For advertisement also, they have to take approval from the director.
Your Lordship, then some observation, your Lordship.
Already we have forwarded the filing order.
They have, Lordship. I have no grievance against the DHA, your Lordship. No grievance against the DHA. But Lordship, some form of interim protection, your Lordship.
No.
Not
The
to fill up.
earlier process has not been
Yes,
taken to
conclusion.
its logical conclusion.
Lordship.
And therefore, without completing the same, even they want to advertise the same, they have to take approval from the higher education,
Lordship.
director higher education.
Lordship.
And for cancellation also, they have to obtain approval.
It is a simple observation not to fill up, your
No.
Lordship. That will help our case, your Lordship.
That question does not arise at this stage.
Lordship, I leave it to your Lordship.
If any such step is taken by them,
Lordship.
you mention the matter
Lordship.
before this court, we will
Lordship.
list it.
Lordship. Lordship.
Or should we fix short date?
Lordship.
2 weeks?
2 weeks, Lordship, dusty because vacations are entering, your Lordship. Maybe some date in the 3rd week of January, your Lordship.
3rd week of January.
Lordship.
Then fix it at 3rd week of January.
Lordship. Lordship.
Item for order is beginning. Item number 44. My lord, time is running out. My learned friend has given a suggestion, Lordship, the matter be taken up because you will take 15 minutes minimum. I will take 10 minutes, 15 minutes minimum. Time is running. So maybe taken up at 2 on Monday, Lordship. He said that on Monday he wants to do.
Okay, all right.
At 2 Monday.
Okay, as agreed by learned advocates of both the parties, basis shall list the matter on Monday at 2 p.m.
Lordship, I'm getting.
This will apply.
Interim order shall continue?
Yes.
Interim order first shall continue.
Items for admission, item number 20. My lord, if your lordship remembers, I think this case already heard from both sides. They wanted a time saying that on 8th, they are going to go for some kind of a hearing. My lord observed that, yes, you can go for hearing, but you can't pass any order without leave of this court. But hearing did not take place. In fact, I was asking my friend every day that my client haven't got any information regarding the hearing. I was reminding the counsel who was representing, I think Mr. Sharma was there. So before the hearing, I was reminding him that my client haven't got any information regarding the hearing you said on 8th. Ultimately, no hearing took place until now. My client also haven't got any information regarding that hearing. So on 8th, they said they're going to go for some hearing. That hearing did not take place. I think
What is the status?
In fact, my lord, my instruction is that the deputy inspector, the petitioner informed the deputy inspector that she cannot attend the hearing on 8/12, as she has left for diplomacy.
Okay.
Petitioner knew about that. my lord.
no, it's impossible.
My lord, that's what my instruction.
This is incorrect
He may
information.
say impossible, my lord, but that is my instruction, my lord, that the deputy.
No, whether a new date is scheduled.
My lord,
New date is scheduled again.
my lord, new date is not scheduled. No, new date is not scheduled, my lord.
My lord,
What to do?
this
We
is-
will finally adjudicate this matter or to wait for your,
We may fix a date, but we can serve it through the council method, the notice. If your lordship allow, we'll serve the notice through the council method to the petitioner.
okay,
I
no
agree.
problem.
I'll inform. In fact, my lord, this is to all respect, my lord, this is incorrect because on 8th evening, my friend from the other side took the phone number of my client from me on 8th evening and through WhatsApp. That record is there.
I'll serve the copy through.
How can the DI say that I informed? I was every time calling and asking, did you get the information for hearing? Did you get the information hearing? And she gave the message in the WhatsApp, no.
So first you schedule the date.
I'll schedule the date, my lord, and will serve the notice through the council. my lord.
Okay.
Lordship will fix it after 2 weeks or after
Okay.
the reopening. my lord.
Okay.
But
Heard Mr.
otherwise-
Abedin, learned counsel. for the
Otherwise,
petition.
hearing is already concluded, my lord.
Then also heard Mr. B. Kosik, learned standing counsel for the respondent in elementary education department. Mr. Kosik submits that though a date has been fixed on 8/12/2025 for hearing, the petitioner could not appear on that day, and therefore hearing could not take place on that day. And now a date will be scheduled, and he submits that he may be permitted to serve the notice to the petitioner through the council, through her counsel, Mr. Abedin. Mr. Abedin submits that he will convey the same to the petitioner. Accordingly, pair of Mr. Kosik stands allowed. Processor lists the matter after 2 weeks on
27 January.
short date.
No, no. আৰু আগত দিয়ক। তাৰমানে তেওঁলোকে মোক জনাব, মই তেতিয়া
And
জনাম।
in the meantime, Mr. Kosik shall apprise this court about the outcome of such hearing. List as per 30.
20 January. Item 21. My lord, only one thing, if your lordship permits, my lord. What my friend has said that I could not appear on that day. I'm categorically stating that I did not get any information prior to 8th. That may be recorded, my
Okay.
lord.
However, Mr. Abedin submits that the petitioner has not received any information in respect of the hearing scheduled on 8/12/2025.
Deeply obliged.
My lord, notice was issued. My lord, no affidavit till date, my lord, Our grievance is very limited, my lord. There is an order passed by this honorable court for our provincialization. My lord. Thereafter, my lord, a contempt petition had also been preferred. And during the course of the contempt, my lord, they have passed an speaking order wherein, my lord, without, my lord, reflecting my name or my post name, my lord, I have been dropped from the purview of provincialization without any reason, my lord. That part of the order is under challenge, my lord. Just for a moment, if my lordship.
No, Mr. Sharma, where is the affidavit?
We have physical instruction, my lord, so sometime may be granted so that we can file our affidavit.
What instruction you have received?
It is my instruction. And we want to file our affidavit here, my lord. On the basis of that instruction.
No, that's all right, but you have granted sufficient time to file the affidavit.
And the last part of the instruction. No, my lord, in the first place, last part. I'm gonna copy the one. Here, copy. Petition. Oh, sure. Or I can use one copy of instruction. And not, and not.
Okay, you file the affidavit. Heard Mr. A.R. Bhuiya, learned counsel for the petitioner. And also heard Mr. U. Sharma, learned standing counsel for the secondary education department. Mr. Sharma submits that he has received instruction and he will bring the same on record by filing an affidavit. And price for granting some time, pair allowed, resolution lays the matter. On the last day, 18th. Nineteenth of December.
January.
No. You filed the affidavit.
Yes, madam.
No, you have already received sometime. No, you make an attempt. We'll see. If you could not, then we will grant you further time. But with cost.
Item 22.
Also, can they have a look, the order dated 11/11.
Pardon?
The close, right? I have provided the order copy.
Oh, to move there. No, it was photo.
Yeah, that's it.
It will be.
Order photo.
So here order to move there. Order to. Itu ki bostu? তো ফটো উঠাওক নেক্সট লগত দুটা ওলাবলে just দি গৈছে
Yes, proceeding is closed.
Close then mele in the light of that my writ petition be closed
Okay.
also.
Heard.
With liberty, my lord, if it is not acted upon. Sometimes, my lord, it remains only in paper.
No, Mr.
Anyway, I
Borboya,
your
you-
lordship, my lord, I am living up to your lordship.
Heard Mr. Borboya, learned
the
counsel
copy,
for
sir.
the petitioner.
Yes, sir. There is just the-
And also heard Mr. P.K. Bora, learned standing counsel for the respondent in elementary education department. Mr. Bora has produced one order dated 6/12/2025 passed by the Director, Elementary Education Assam. And on the basis of said order, Mr. Bora submits that the
Hola,
departmental
time
proceeding
flying.
initiated against the petitioner has been closed.
Para 4 of the order.
Closed.
Thereafter, we are finding an inquiry
A
committee.
copy of the said order is furnished to Mr. Borboya, learned counsel for the petitioner. Mr. Borboya submits that in view of the order being passed by the Director of Elementary Education, the writ petition may be closed. Accordingly, taking note of the submission of learned counsel for both the parties, the writ petition stands closed. The order produced before the court today shall be marked as Annexure A and be tagged with the report.
Lordship, this is pertaining to Lordship, my claim for area salary for a particular period and Lordship, my conversion of post. I was a science graduate teacher, my post was converted as an assistant teacher without my knowledge. Lordship, an affidavit will be required from the respondent.
But in this case, absolutely negative sign. After 3 weeks, my lord, in the file.
After 3 weeks, madam, you see, this order was passed on 22nd of August 2025. Almost 4 months back.
My lord, the second time when it just come, my lord. That
No. It is not the rule that only after quarters of fifth date you will file your affidavit. Heard Mr. Das, learned counsel for the petitioner, Ms. Sutia, learned standing counsel for the respondent in elementary education department. Ms. Sutia submits that she has not received the instruction and she pressed for listing the matter after 3 weeks. So that she may file an affidavit after receipt of the instruction from the department. They are allowed to list the matter in the second week.
21st.
21st.
24.
I have to find out because I have not received this. Because, but this.
But whether you inform the matter to the department,
Yes, my lord.
when,
I have informed, my lord.
when and how?
Okay, yeah, they have later to the district matter to submit the report matter. So.
Mr. Sharma?
My lord, today is the, my lord, date fixed for consideration of GPFM on, my lord. So for the release of GPFM on, my lord. That means lordship will find order dated 26/11. The GPF amount is, my lord, deposited in my GPF account, my lord, from the
GPF
salary.
account, no, GPF amount has to be released by the AG.
My lord, AG is part.
Yes.
On behalf of Mr. V. Sharma, due to some personal difficulties, we have to leave the court today. So I
No,
have-
that's all right. Whether that information is available with you, that why the amount could not be released?
My lord, I don't have the instruction. Regarding the fee.
That as per my instruction, my lord, the particulars of the document has been forwarded to the, my lord, AG.
AG. So you obtain instruction and on next date you inform the court? Why the GPF amount has not been released? Heard Mr. R. Sharma, learned counsel for the petitioner, Ms. N. Popon, learned standing counsel for the respondent in elementary education department, and Ms. Sharma for respondent Ms. Sharma appearing on behalf of Mr. B. Sharma, learned standing counsel for the respondent number 6.
Yes.
And any
And for the 1 to 4 and 5 maybe. 1 to 5.
who is for respondent number 7 and 8?
Director of Pension Government.
Ms. Popon submits that she has not received the instruction and she pressed for granting her some time. Mr. Sharma, learned counsel for the petitioner, submits that today is fixed for consideration of interim direction. No, for an interim direction that the GPF amount should be released to the petitioner. But Ms. Sharma, learned counsel appearing on behalf of Mr. B. Sharma, learned standing counsel for the AG, submits that the information is not available with her. And she also prays for granting her some time. They are allowed to list the matter on
28 January.
28 January. In the meantime, Ms. Sharma shall obtain instruction regarding the status of releasing the GPF amount in favor of the petitioner on next date.
My lord, one thing, my lord, in the order, my lord, 26/11/15/25, my lord,
my lord, the order impugned, my lord, whole order has been, my lord, reflected, my lord. In fact, we have challenged the condition put in the order, my lord. That is.
Which part?
In the order, my lord, 2611, my lord, in the top, my lord. Challenge the order, my lord. And page 28 is our prayer, my lord.
Okay, let them file
My
affidavit.
lord, my
in.
lord.
Turning 42.
My instruction is that the officers when they are, they did not, it was their mistake, I will say, because they did not, recorded their name. However, while examining, they found, now this situation is that without, any order of this honorable court, we cannot seek that documents, the attendance sheet. So I pray, pass an order, either appointing advocate commissioner or to the authority to seize that, seize the attendance sheet, It will be clear, As per my instruction, there were manipulations in the attendance sheet. And some of the students are still, participating in the exam, And without going through the records, interference of the suspension order amount to the final order in the humble submission. And this is the explanation.
No, Mr. Das, you see, the inquiry committee has visited the college,
Yes,
interacted with all the stakeholders, and checked the documents also.
Yes, madam. They ought to have recorded the names, madam. They ought to have recorded the names.
You see, they are not the ordinary persons, they are the joint director of higher education. And one is deputy director of higher education. Can it be expected from the members of the inquiry committee of that stature?
Except these two events, petitioner has no.
So, no, even if it is accepted for argument that there is manipulation, now how can you establish that the person, the students who have secured less than 50% attendance are allowed to participate in the examination?
There,
How?
no, the students who are now sitting in the exam, some of them are, as per my instruction, some of them doesn't have 70% attendance. So that will be.
No, merely allowing someone to appear does not mean that he had resorted to some malpractice there. Because the statute has given him some discretion, and he even after applying that discretion, he has granted someone to appear, permission to appear in the examination. Can you challenge it? Can you take it as a misconduct?
In my humble submission, the principal cannot go beyond the Bar Council of India rules, which mandates that 70% attendance is mandatory, For that, I have to file a affidavit, in this. Because today,
No,
matter
you
is
see,
motion is stage, and
whatever be the stage, is there any bar in passing an order at the motion stage?
No, there is no.
Then-
But the thing is that if the interim interim order is amounts to passing of a final order, then
Maybe if it is grossly illegal, then why should not we interfere with it?
here the case is on the facts, factual disputes regarding manipulation of records, What I'm saying, that's what, my lord, that's why, what.
No,
I'm
no,
saying, my lord,
in the
Let- let
inquiry
the- let
report,
the-
you show me where is the observation that there is manipulation of record? You show this
No, their inquiry report, I think, no, there.
where?
Nothing, not a single word. You-
Manipulation means, my lord, they he
Hmm?
allowed certain students, my lord. Inquiry report, my lord. It can
Hmm?
report.
Where it is stated? You show me?
Manipulation word is not there, my lord.
What is there then?
That is that, if, my lord, read from second paragraph, it is the version of the principal, then third, he further stated that the decision related to non-collegiate students was taken after discussion with the faculty members of the teachers in charge. Contrary to principal's statements, the students allege that the principal acted in a biased manner while several students with attendance below 50% were allowed to appear in the examination. Others with similar or slightly higher attendance were denied permission. They asserted that the principal selectively applied the attendance norms. The faculty members gave a version different from that of the principal. They stated that during discussion, they had suggested that if some low attending students were being allowed to appear, then all students falling in the same category should be given equal opportunity. However, the principal did not extend their recommendation and proceeded with its own decision. After hearing all parties, students, teachers, and the principal, and verifying the relevant attendance record and documents, the following observations were made. 2 students with attendance below 50% were allowed to appear in the examination, which is in direct violation of record. The principal failed to apply BCI regulations uniformly. This is what the principals claimed that the decision was collectively taken with faculty members is contrary to the faculty who denied agreeing to the selective permission granted. The principal did not cooperate effectively during the inquiry and failed to uphold the dignity, integrity and administrative responsibility expected to the head of the only government law college in the state. The inquiry clearly indicates that the principal violated the statutory norms of the Bar Council of India by permitting ineligible students to appear.
No, no, Mr. Das, you see, this finding number 4,
Yeah,
it is contrary to the paragraph number 2 of the inquiry report.
paragraph 2, man.
2. You see, there it is stated that during the visit, the principal, faculty members, and the concerned students were interacted with, and relevant documents were examined.
Yeah, man.
Hmm?
It is interacted with and 11 documents were examined.
Hmm. Then how he has not cooperated with the inquiry committee? How?
But how he has not cooperated?
Merely because that the principal has not conceded to the demand of the students. And as per the direction of the higher ups, you have placed him under suspension. Hmm? Why should not we interfere with the same?
Without going into the records, my lord, my lords may not interfere with the suspension order because at this stage it will amount to, my lord,
No, you have given, you have You have given the opportunity to verify the record. You have verified it.
Yes, madam.
Where is the name?
My specific matter submission is that they have verified. The only mistake committed the enquiry officers were that they did not see that the attendance is at that relevant point of time. Later, when they went, the petitioner, lost the attendance registered and it went there, from there. And it's if orders for taking those documents, through an advocate commissioner or the departmental authority, it will not harm anybody, if the case of the petitioner is genuine. If the petitioner has not allowed students who have below 50% marks, it will not happen. It is the marks.
No, what purpose will be served if according to your own submission, the documents were manipulated?
What my instruction is that there were attendance.
How would you establish the source?
That's what record is necessary.
If the record is already manipulated as per your own submission?
If there are overwritten correction, that will give some.
Mr. Sharma, those documents were within your custody now.
My lord, it is specific. Lordship may please come to page 17.
No,
The
you
lordship-
please answer my query.
Yes.
It is within your custody. The documents were within your custody.
Yes.
Can you produce it before the court on Monday?
Yes. Lordship, I will bring everything, Lordship, but the Lordship may please come. There, what they find, it is on record, Lordship, at page 17. Page 17, Lordship, see. It is black and white, Lordship. What's wrong? I have read that page fast. Page 17, Lordship, please come. Page 17, para 19. Why all these documents required, Lordship? It is black and white, Lordship, it is there. And Lordship, on what I said, that the petitioner stated on the basis of permission granted by the controller of examination, Guwahati University, in favor of the two students, namely Ankita Goswami and Jaber Rahman. So and so they were allowed to appear in the examination. Get it? Then, Lordship, this controller of examination withdrawn. I have shown that letter. Accordingly, Lordship, now read. Accordingly, from 9/12/25, not a single student of BRM Law College could take the in conversation with the Rule 12 of the Bar Council Rule. On oath, Lordship. On oath, Lordship, I have said there is no one.
Okay.
So let's
Mr.
go ahead.
Sharma,
Let's go ahead with this. This is on oath, Lordship. If I have said something wrong, I'll go to jail. I'm a principal. Whole thing is based on a false record, false people, and Lordship, this is the Supreme Court judgment directly, Lordship, this para 32 on that. They have no
Okay,
legs to stand.
Mr. Sharma,
I Monday,
time
any
is
day, Lordship,
running
I
out.
think.
We will fix the matter on Monday.
Yes, Lordship, but till then, Lordship, no courtship, Lordship. No courtship action.
No coercive means?
No further courtship action, Lordship. Because I'll go, Lordship will allow me. Yes, I'll bring it. তাকে কৈছো মই যদি মোক আনিম কোর্টে I'll go because until and unless Lordship don't give an order that I'll bring those things, I cannot enter there. They will not allow me.
No, whether that letter of the this controller of examination on the basis of which you have allowed two students to appear is with you.
Yes.
On record.
On record, it is there,
No,
Lordship.
no, it is in your statement in the writ petition.
No, annexer, Lordship.
Annexer.
Page 49.
Okay, let it be on Monday.
No courtship action till then, Lordship.
Okay.
No courtship action. I'll produce everything, Lordship.